if you are a consumer of independent news, then the first place you should be going to is Consortium News, and please do try to support them when you can. It doesn't have its articles behind a paywall. It's free for everyone. It's one of the best news sites out there, and it's been in the business of independent journalism and adversarial independent journalism for over 2 decades. I hope that with the public's continuing support of Consortium News, it will continue for a very long time to come. Thank you so much.
Get out your notebook. There's more.
Welcome to CNLive, episode 17 of season 2, A Sense of Justice. I'm Joe Loria, editor-in-chief of Consortium News.
And I'm Elizabeth Voss.
22 days of testimony in the Julian Assange extradition hearing at the Old Bailey in London have ended. The defense will submit its closing argument on November 16, the prosecution 2 weeks after that, and then Judge Vanessa Barreza will make her decision on Judgment Day, January 4, 2021. When the judge in Daniel Ellsberg's 1972 trial threw his case out because of government misconduct, he said he acted because the government had, quote, offended a sense of justice. The Nixon administration desperately wanted to punish Ellsberg. Nixon's plumbers broke into his psychiatrist's office to try to steal his medical files. Nixon had Ellsberg illegally wiretapped. The government said it lost the wiretaps when asked to produce them at trial. And finally, the government tried to bribe Ellsberg's judge with the directorship of the FBI. Compare that with the U.S. intelligence contracting the Spanish firm UC Global to spy 24/7 on Julian Assange in the Ecuadorian embassy, and especially on his privileged conversations with his attorneys, with his doctors and journalists visiting, stealing defense documents, as well as discussing plans to kidnap or poison him. All that came out in testimony on Wednesday by 2 anonymous witnesses in a Spanish trial. Dan Ellsberg wrote in an email after hearing about this testimony, quote, "That's essentially the same information that ended my case and confronted Nixon with impeachment, leading to his resignation. In other words, Julian may miraculously walk free on the basis of this eventually, just as I did. Will it be enough, though, to set Assange free as it did Ellsberg?" We'll be speaking to Dan Ellsberg shortly, and he will be interviewed by legal analyst Alexander Mercouris, my co-host Elizabeth Voss, and by me. Kim.com was unable to join us, but CNLive will be interviewing him next week. To set up the story of the U.S. surveillance of Assange at the embassy, we'll begin by watching this short clip from the recently released documentary War on Journalism by Juan Passarelli.
Welcome to the State Department. I think we have some interns in the back. Welcome. Good to see you in this exercise in transparency and democracy.
The CIA is equipped with a variety of hacking tools to crack into phones, cars, computers, even smart TVs.
As a result of these publications, in 2017, the newly appointed director of the CIA, Mike Pompeo, in an unprecedented manner, dedicated his first public address to a publisher.
Julian Assange and his kind are not the slightest bit interested in improving civil liberties or enhancing personal freedom. They have pretended America's First Amendment freedoms shield them from justice. They may have believed that, but they are wrong. WikiLeaks walks like a hostile intelligence service and talks like a hostile intelligence service.
The private security company UC Global, hired by Ecuador to protect Assange, cut a deal with the CIA to spy on Assange and the Ecuadorian diplomats.
Together with these is the immediate accessibility to the newest major exposition, convention, and meeting facility in the city of Las Vegas.
In 2016, the owner of UC Global, David Morales, flew to Las Vegas to attend a security fair.
As soon as Morales returned from this fateful trip to Las Vegas, he began bragging to his employees back in southern Spain that we will from now on be playing in the first division, using a soccer metaphor, a football metaphor. But they were violating their contract with Ecuador and secretly working for the Americans via Sheldon Adelson.
The CIA laundered payments to UC Global through Las Vegas Sands, a company owned by Trump mega donor Sheldon Adelson.
Una persona que no se identifica, me contacta, me llama por teléfono y recuerdo perfectamente que cuando comienza la conversación me indica: hola, tú no me conoces, pero yo a ti sí te conozco perfectamente. Entonces yo le pregunto: ¿pero y de qué me conoces? Y él me indica: te conozco porque durante mucho tiempo has sido uno de mis objetivos. Te he seguido, te he grabado, he escuchado tus conversaciones, tengo toda tu documentación personal, tu pasaporte. Durante un montón de tiempo has sido uno de mis principales objetivos.
An elaborate plan was set up between Morales and the CIA to install surveillance cameras with audio capabilities and implant covert microphones in strategic places, such as below this fire extinguisher in the embassy's meeting room and behind this box in the toilet. Assange held meetings in this toilet for fear of being spied on.
En lugar de proteger a Julian Assange, se dedicaron en forma absolutamente ilegal, atentando contra el derecho a la privacidad, atentando contra los derechos humanos, a espiar a Julian Assange, cooptados por la CIA.
The CIA's increasing obsession to entrap Assange alarmed a UC Global staffer who blew the whistle when asked to target Assange's family and even plot an attempt against his life.
They came forward and they spoke to our lawyers and they exposed what had been going on there because they had played a part in it. And they said that what their boss had been telling them is that they were working for the CIA and that those instructions about getting Gabriel's DNA, that was coming from the other side of the Atlantic. These instructions were coming from the United States.
It reads like some really terrible spy novel. Plots to kidnap, plots to possibly poison Julian Assange while he was in the embassy. I mean, it's almost too crazy to be real.
And it is real. It's hard for people to understand that such lawlessness is possible. So there's incredible criminality that has been going on in order to gather information about Julian's lawyers and his family and journalists who were visiting him. I mean, it's shocking, and I'm very fearful. I've been in a permanent state of fear for years.
UC Global sent video, audio, and other information about Assange, WikiLeaks staff, his visitors, and the Ecuadorian diplomats to a CIA server. They also recorded Assange's medical consultations and went as far as recording Assange's privileged legal conversations with his lawyers.
When Daniel Ellsberg was on trial for the Pentagon Papers during the Vietnam War, his case was thrown out because it came out that Nixon had ordered a raid on his psychologist's office to try and get information which was embarrassing to Ellsberg. So, of course, that should have happened, and it was right that it happened. Assange has been surveilled by the CIA. That by itself should mean the case is thrown out. There's no chance you can have a fair trial if the people who are prosecuting have been surveying the defendant as he's been having privileged conversations with his lawyers. It's completely irregular that it hasn't been thrown out on those grounds already. I mean, really is outrageous.
And we're here actually with Daniel Ellsberg. Dan, thanks for being with us. He's on mute. He has to be unmuted. Okay, Dan, thank you. We just heard Matt Kenner, journalist Matt Kenner, in that clip speak about the parallels between what happened to you and to Assange and how striking they are. Could you tell us, Dan, what leads you to think that Assange's freedom could come as it did yours?
As I've told you before, Joe, watching this trial, mainly your recording, has forced me to relive my trial, 4.5 months, which was a very unpleasant matter. It wasn't really fun to do it. What I'm seeing now in the last few days is the glorious last week or so, 10 days of my trial, when day after day, news came out under new testimony of government crimes against me. I'll never forget the day, April 27th, 1973, when the word came out in my courtroom from the judge that the White House, the Oval Office, had ordered the burglarization of my former psychoanalyst by, in large part, CIA assets in general. There was pandemonium in the courtroom. As soon as he'd said that, the entire panel of reporters at the back of the room, who'd been sitting there very frustrated for months, being stuck in Los Angeles while Watergate was erupting across the country in Washington, they jumped out of their seats, ran to the hall for payphones. Watergate had met the Pentagon Papers case at last, and this was extremely exciting news. Criminal acts by the White House against American citizen on trial. In this case, we don't have an American citizen. We have an Australian, an Ecuadorian, who's being trying to extradite to the United States for a United States alleged crime, very problematic in itself. Okay, something that struck me just now, Joe, moments ago, is this. I don't think the New York Times has had a word about these amazing revelations under oath now. We're hearing it from you. We heard just a very dramatic film segment on this program. People watching this get to see it. I just looked up on Google News the last time the New York Times, I said New York Times on Assange, September 16th. That was more than 2 weeks ago. It happened to be the day, their last was the day that I testified, but they didn't have that. They didn't have anything on it, in fact, but it was the day that I testified. The point is, absolute blackout on this, on the mainstream news. Now, how can that be? These are sensational revelations. They are, if traced to the Oval Office, as they surely will be, could be. This is the CIA acting not as a rogue agency. It is acting as they normally do for the Oval Office, as the secret police arm of the White House. This is very clearly a high crime and misdemeanor. This is an impeachable defense, if there were such a thing, with the Senate. Strictly speaking, this president is unimpeachable, as he understands, and is clear. He's free. He's clear of the Constitution, of anything else with this Republican Senate. But were it not the case, in fact, if we should be so tragically unfortunate as to see 4 more years of Donald Trump, which is not impossible, and if we should also get a Democratic Senate, nevertheless, in spite of that, this would clearly be an impeachable offense. And he might then not be unimpeachable, just conceivably. Now, I hope it doesn't come to that. But the bright news here is that this trial should end the way my trial ended. And that's has several parts to it, one better than the next. The extradition should be out of the question now. I would say, by the way, that it's insufferable for Julian Assange to be kept 3 months in isolation in this prison until he hears a judgment from this judge in January, when she has received this information. It doesn't take 3 months to say, no man should be sent to a jurisdiction which has already done this, has already intervened illegally in all of his conversations with his lawyers, prevented him from having anything like a fair trial. I testified that was already true before we learned this, to send him to a country that did not have an Official Secrets Act, that was misusing the Espionage Act as if it were an Official Secrets Act, unconstitutionally. That was, he should not be sent there. But with this, no criminal of whatever charge, imagine the charge, murder, traffic violence, whatever, could get a fair trial under perfectly constitutional laws when his privacy with his lawyers has been so interfered with, and there have been such offenses and offending a sense of justice as discussions of kidnapping him and killing him, poisoning him. Now, discussions of killing me did go on. In that case, that was something else that came on. That's something I learned about our government. It was news to me when that came out. that discussions of killing an American citizen would go on in official channels, as they had in my case. And but here we have it again. So the trial, the extradition should be over. I mean, it should be over within a week. Her schedule should be revised. The closing arguments in a couple of weeks. It shouldn't have to go that long, but months to January, that's absurd. Waiting on the second. The trial should be ended. There should be no question of trial in the United States. There should be at least a House investigation immediately on these charges and on what's going on in the CIA and who else they've been doing this to. There's no reason to believe at all that Julian Assange is the only person who's been subject to this kind of intervention. So, okay, the trial should be over. Now, in my case, these very clear-cut criminal acts by the White House led to impeachment hearings, which forced the president to resign, making the Vietnam War endable within 9 months with Nixon out of there. How about, let me come back to that in a moment, because there's a very clear line of correspondence there. But a third thing is that the, well, no, I'm sorry. Let me pursue that for just a moment. It's very important. Congress actually cut off the funding for Yemen, the Yemen war, the clear crime against the peace in which the U.S. is participating, has been now for years in its assistance, providing bombs, directions, targeted directions, logistics, refueling to Saudi planes that are bombing civilians in Yemen. So even the Republican Senate cut off the funding for that. In the House, it was led by Bernie Sanders, and they cut it off. The president vetoed that. So it goes on. The crime against the peace goes on. But because of his ability to veto that. In the case of the Watergate hearings, which had begun breaking open just before my trial ended and in connection with it, the House cut off funding for the Vietnam War for the first time. And let me say, I think that was the first time I know of in any legislature that had ended funding for war during that war, to cut off the war. The Yemen case may be the second time. I'm not aware of any time in between in any legislature where that's happened. So in Yemen, led by Bernie Sanders, they imitated what happened during Watergate in the fight with the president. The specific incident, by the way, that tipped it was that they didn't, the president wasn't allowing Dean to testify to Watergate. And so the Congress, in kind of retaliation against that, took its power in its hands finally under the Constitution and used its funding power to cut it off. The funding was cut off on May 10th, as I recall, one day before my trial ended. But the president couldn't veto that. It got passed by the Senate as well, to cut off funding for Vietnam. The president would normally have vetoed that, as Trump just did with Yemen. But he couldn't, because John Dean had, days before, revealed the break-in to my former psychoanalyst office, the burglary, and Nixon, comparison here, Nixon knew that he would be facing impeachment, and he could not afford to have two fights going on at once. A fight on impeachment, where he would need all the votes he could get, and a fight on ending the war. So he did not veto it. And in negotiations, the funding was cut off eventually. They agreed on August, on keeping the bombing going until August, and then it was cut off. Again, that could happen. The president's, well, I don't know. This president isn't worrying about impeachment at this point. So there's a difference there. But we can aim at this having effects on our foreign policy as well, because the president should be facing prosecution charges on these crimes. Will he? Well, we'll see. How much has changed? 50 years. Yeah, the president can get away with things that he could not before. We have a monarchical president to a greater degree than Nixon. Remember, Nixon was the one who said after he was out of office to David Frost, in connection with the break-in to my psychoanalyst office, he said, when the president does it, it's not illegal. That was an indication, connection with me on that. And that's, of course, what Trump has been operating on throughout here. So the question up to us in this election in the first place, a month away, and in all our dealings from now on is, should the presidents, and Trump is neither the first nor the last president to think in this way, should the president be allowed to believe when the president does it, it's not illegal? He's beyond the law, he's beyond the Constitution, he's beyond any treaty. That's the way he's been operating. This could be one more thing that poses the challenge to him on that question, whether we have a king, as in effect we have had for some time. Do we continue to have a king? Do we have a dictator, a Mussolini, Il Duce, or not? Or do we have a president who is subject to the law and to the restraints of the Constitution? So I would say this is, I have to say, a glorious day for the Assange defense in the first case. The part that he'll remember, I suspect, with some pleasure, the only time probably in years that is true, depending, of course, on how it comes out from here now. And that depends on us. And it depends on places like the New York Times, which is shameful that it has not been covering this. Neither has the Washington Post. There was one AP story, I think 2 days ago. They haven't even picked up a AP story. And I know an exact parallel to this. I remember when I saw the news that someone, turned out to be Catherine Gunn in England, that someone had revealed NSA, National Security Agency, operational crimes of ordering that there should be asking the British, actually, rather, not ordering, but asking the British friends, GCHQ, the counterpart to NSA, to bug, as in the Assange case, the home and office phones of every member of the National Security Council, in particular the non-permanent members, vote they hope to change. And again, in the case of a war, in the case of the Iraq War. And I saw that. I saw there hasn't been a leak like that ever. That was at a higher, that was not only at a higher classification than I'd ever seen in the press. I knew that was something more highly classified than I had. I had 12 compartmented clearances, higher than top secret, and I had a clearance for the results of communications intelligence. That's a relatively low level one. This I saw right away was operational. Who are we targeting? As in the case of Assange. It's like the orders of what to do with Assange, how to place the microphones, how to do it here and there. I wasn't cleared for that. Hi, I'm looking at John Kiriakou sharing the screen with me here. I imagine of course he was in that process. He did have those clearances. I said, okay, someone's conscience who has very high access here is leading them. Okay, that was headline news everywhere in the world, except America. Not a word on the New York Times that day or the next day. Headlines everywhere. CIA is manipulating the Security Council. The Security Council included a couple of people whose regimes had been subject to CIA manipulation. Mexico, there were a couple of others. Their people were not happy at the thought that their counselors were being subject to blackmail by the CIA, and they made it impossible to vote for the Iraq War. Catherine Gunn did that. It didn't keep England from going ahead, even though Blair had said, we won't go without a second resolution. And that resolution had suddenly become impossible because of Catherine Gunn's leak and the revolution here. Okay, in the New York Times, nothing. So in the Washington Post, actually, I remember that Scott Shane in the Baltimore Sun had a story. The LA Times and the Washington Post had little stories saying, oh, this happens all the time. It's really nothing much. Everybody expects it, and so forth. That was not the way it was treated in these other countries. Later in the year, I was called by a reporter whose name slips my mind at the moment, and from the New York Times, because Catherine Gunn was about to go to trial. So it'll come back to me. He was very good. Bob Herbert. And he was not a news reporter. He was an op-ed writer, an editorial writer. So I'd never talked to him before. So he won my opinion because my name was used a lot in connection. I'd been supporting Catherine Gunn. As a whistleblower, I'd said that this was a more effective leak in preventing a war than the Pentagon Papers. So it was widely quoted in Europe. He called me to ask me for my opinion about it. I said, Bob, you know, this was 9 months after her arrest. Bob, this will be the first time her name has appeared in the New York Times. And he said, you know, Dan, you're right. I just looked up in LexisNexis this morning in our morgue to see the files, and there wasn't anything. He said, Bob said to me, how do you understand that? I said, Bob, you're asking me? You're on the Times. Go to your ombudsman and ask him this. I suspect that the reason was at that time that the New York Times had gotten a phone call from NSA, or in the White House perhaps also, saying, and they in turn to the Times, I forget how I said that, but the Times had gotten a phone call from the White House or NSA saying, this is communications intelligence. This is highly classified. Stay away from it. And they did. And I think that's what happened, effectively a censorship, what they call a D notice in England, which we don't have officially over here, prior censorship restraint. I think that's happening now. I can't understand this otherwise. This is sensational news, amazing. Sworn testimony by the people who actually carried out the penetrations. We didn't have that in the Plumbers case. Liddy and Hunt kept their mouths shut. Liddy, because he was an American neo-Nazi and loved to obey the Fuhrer, and Hunt because he was paid $140,000 and he had testified falsely that he didn't know any of this. So we didn't hear this testimony about the people who actually did it. Here's what we're getting right now from the top of the firm. Let's watch, I put it to you finally here, let's watch and see how the American press handles this.
And as you said, then they didn't cover these Spanish testimonies. And by the way, they're not classified. This testimony,
it's in
there was this excuse that, you know, it's highly classified, stay away from it. I want to go around the room and go to John and Elizabeth and Alexander, but a very quick historical point I want to ask: how did it become known that you were being bugged, wiretapped at psychiatrist's office? You said it came out in court. How did that happen?
Okay, John Dean was facing, and it's worth saying, John Dean had told the White House that as a lawyer, he was not going to commit perjury, which needless to say worried them because they were going to dump the entire cover-up on John Dean of Watergate. Now, he was involved. He did operationally run the cover-up, but with the help, of course, of a lot of people. And John Dean became aware that they were going to dump the entire thing on him, and that Haldeman and Ehrlichman in the White House were going to get away with it, essentially. So he was telling his lawyers that various things that he might make some kind of a plea bargain with them, and they weren't accepting it. And he did not want to involve the president. I never asked him exactly what his hesitation were, but it's natural, it's universal. For one thing, I don't know how much responsibility he felt to this particular president, but taking on the president is never safe for anybody. And it's not something you try to do. The resources of a president to get at you in various ways are just too great. So eventually, in the course of his bargaining, he told them what he knew about the break-in to the psychoanalyst office, which he'd been told by Egil Krogh, who was the chief of the so-called Plumbers, the special investigative unit. And he told him about that. Krogh had told them also, he knew also from other ways about the orders to incapacitate Daniel Ellsberg on the steps of the Capitol on May 3rd, 1972. And let me go on that a moment because the exact parallel with Assange. They were talking about silencing Assange by kidnapping him or in the Ecuadorian embassy, breaking diplomatic immunity at that point, or poisoning him, killing him. Why that? To silence him, to keep him shut, his mouth shut. So when I heard later, after my trial had ended, I talked to the special prosecutor who told me about this plot He said the words were to incapacitate you totally. And I said, well, what does that mean? Kill me? And he said, the words were to incapacitate you totally. He said, however, these guys, meaning CIA assets, never use the word kill. They talk about neutralize, terminate with extreme prejudice. That was another murder that occurred in South Vietnam, and so forth. They say they don't use the word kill. Somebody might overhear them, actually, euphemism. So in some case. So he had no doubt that I was to be killed. I did doubt that. I knew they wanted me to shut up about the mining of Haiphong, which was about to come, and the B-52 raids, which I was talking about. And they wanted me to shut up about that because the mining, this was May 3rd, the mining took place on May 8th. And that not only posed the possibility of armed conflict with the Soviet Union because they had ships in the harbor of Haiphong, but in particular, I was talking about the massive use of B-52s over North Vietnam, which had never happened up till that time, and which did happen then. So they wanted me to shut up. And one of them, Bernard Macho Barker from the Bay of Pigs, later told a journalist friend of mine, my directives were to break both his legs. But that wouldn't shut me up. I don't think that was they had 12 people on this process, and all from the Bay of Pigs. And I think at least my jaw was going to be wired shut somehow for at least a while. This is what was going on with Assange. And by the way, to again bring this up to date, when Snowden, who had, I think wasn't even yet identified, but when in fact he was in Hong Kong and the CIA was searching for him all over the world, I was saying the person who did this is in physical danger. I have no doubt, by the way, they would have killed Snowden if they could have done it before his name became a household word, before people knew who had done it, so forth. So a number of people said, in writing, said Ellsberg has lost it now. He's really gone off the wall here, talking about killing an American citizen. And I remember saying to at least one of them, you're looking at someone who had 12 CIA assets brought up from Miami with orders to incapacitate me by the President of the United States. And of course, all this was, I think, before we knew that Barack Obama had a kill list on which was the name of Anwar al-Awlaki, an American citizen born in this country. And he ordered him killed, and he was killed with a drone. And a couple of weeks later, his 16-year-old son was killed by a drone, apparently on the process of looking for his father. So that does happen. And whereas in my case, those charges led to the impeachment of a president, in the case of Anwar al-Awlaki, I didn't see any move for impeaching Barack Obama on this kill list that he looked at every Tuesday. This had become normalized. Every crime that was done against me had, which led to impeachment proceedings, a major part of impeachment proceedings against Nixon, has been in effect legalized or normalized since 9/11 for presidents, Democratic and Republican. That's how far our country has moved to an autocratic government.
And I want to come back to that very point. I think that's important, and we've got another video to play about that. But let me bring in John Kiriakou quickly and then turn it over to Elizabeth and Alexander. John, the testimony by these two Spanish UC Global former employee and partner, one of them was, he testified that he asked David Morales, who founded this and ran this operation. Morales, of course, it was a small operation. They only had the Ecuador contract. He goes to the US, he comes back and says, we are in the big leagues now. We've moved into the dark side. The Americans are going to give us contractors, our American friends. And this witness asked him, who are these American friends? And he said, US intelligence. And then the witness asked him, could you be more specific? And the witness said he was cut off at that point. So we don't really know if it was the CIA, but I think it could only be the CIA or the NSA that would be able to run this surveillance operation. The CIA has the big electronic unit that nobody ever talks about. So I just wanted to ask you who do you think it was, and give us some general ideas about, from your own experience, how this is not very far-fetched, is it, that the CIA would do such a thing? Like, if it was the CIA.
No, it's not at all far-fetched, Joe. And I think it was the CIA, because NSA isn't operational in the sense that the CIA is operational. where the CIA has people trained in intelligence collection going out around the world to recruit spies, to steal secrets, to plant bugs, and to collect information. NSA doesn't do that. NSA pulls the information out of the air. So and to do it operationally, that would fall to the CIA. One of the things that's sort of stuck in my mind, though, as we've watched these various witnesses in the hearings in the UK, is that the CIA went to this Spanish company that nobody's ever heard of. What I don't understand is why, when they have NSA, when they have GCHQ, when they have their own operational components that they can use against Julian Assange, why go to this Spanish company? And I think what they did was they just went everywhere. They cast as wide a net as they could. Remember, they have an unlimited budget to do these kinds of operations.
A moment, John. They already had the contract in the embassy. Maybe that's why. They had cameras in the embassy.
Yeah, they already had the security contract at the embassy. They did. They had the cameras. It was a question of installing microphones if those weren't already installed. And, I think that the CIA's attitude on things like this is the more the merrier. You throw a ton of money at this company, make them happy, make their families happy because all this new money is coming in. They get to cooperate and work alongside the big boys. And then at the same time, you still have NSA and GCHQ and other components working to spy on Julian.
Okay, let's move on to Elizabeth, please. Thank you.
Yeah, I have another question for John, and that is just to ask, and I know that you've discussed this many times over the months and years, but can you describe for those who still don't understand the type of trial, the type of quote unquote justice that Assange would face if he were extradited to the United States? Can you just explain that briefly from your experience?
You bet. And I'll preface this by saying that I had dinner just 2 nights ago with Daniel Hale, who is the drone whistleblower and who is also facing an espionage trial in the Eastern District of Virginia. So Julian, were he to be extradited, would go to the Eastern District of Virginia. I've spoken at length publicly about my judge, that was Judge Leonie Brinkema, who also assigned the Snowden case to herself, who assigned the Zacharias Moussaoui case to herself. We all thought that she would assign Julian's case to herself. Instead, it went to another judge. And before we celebrate that, we need to look at this judge. And before he went to the Eastern District of Virginia, he was a judge on the FISA court. So this is not somebody used to giving national security defendants the benefit of the doubt. Daniel Hale right now, literally this week, next week, is going through something that I went through in the run-up to my trial and something that Julian will face very, very soon. And that is something called a SIPA hearing. It stands for the Classified Information Protection Act. So what they'll do is they will clear the courtroom of everybody except the judge, the prosecutors, Julian and his attorneys, the jury, and the clerk. That's it. And then they cover up the windows with plastic sheeting and tape the sheeting up there so the Russians can't fire a beam at the window and read the vibrations off the window to see what's being said in the courtroom. And then they take duct tape and they put it around the door frame so whispers can't leak out under the door. It's really quite over the top. But then, and this is really the damaging part, they'll go through what will probably be a very long list of words or phrases or even actions that are not permitted to be uttered in the courtroom. And so instead of them saying that Julian Assange is accused of leaking classified information related to XYZ, XYZ will be replaced by the words, let's say, swimming pool. So they'll say, Julian Assange is being accused of leaking information related to swimming pool. And then the jury is going to look on their list of banned words and they're going to see swimming pool relates to war crimes. Okay, so we know it's war crimes. Well, all this does is it serves to confuse the jury. And it's going to lead them to conclude that, my God, if these words are so sensitive, they are so highly classified, the government went to all this trouble to bring this guy out of the Ecuadorian embassy through the British judicial system into the United States, he has to be guilty. Otherwise, they wouldn't have gone to all this trouble, right? Otherwise, they wouldn't have gone to the trouble of even making a list of banned words. And so it's dangerous for someone who is seeking justice. I've said it before, Elizabeth, and I'll say it again. I don't think justice is possible. I mean, Julian Assange, as my dear friend Dan Ellsberg said, Julian Assange should be celebrated and thanked and rewarded for the public service that he has given the American people in exposing these crimes against humanity and war crimes. And instead, he's being silenced. And the plan is that he be humiliated in a court that is known as the espionage court, because no national security defendant has ever won a case there.
Alexander, can you weigh in, please?
Yes, absolutely. Daniel Ellsberg, I mean, one of the things that I found most extraordinary from what you just said was the response of the judge in your case to all of these revelations, because I was just in the proceedings yesterday, and one of the things that I found incredibly depressing was the banality of the proceedings themselves and the complete, all I can say is lack of engagement of the judge with them, and compared to the momentous nature of what was actually being disclosed all the time. So, I mean, was the judge, when he heard all of this, and how did he respond? You mentioned the media, you mentioned the lawyers. I mean, was there electricity in the courtroom? Did the judge immediately come in and say, look, we can't go on with this case? Is that the kind of response that happened in yours? Because if it was, the contrast with what I saw yesterday, it would be stark.
You're asking me, well, may I answer? Shall I answer that now?
Yeah.
It's interesting. The response I described by the journalists was very strong. In the judge's case, we now know from tapes what had just preceded that. When Joe asked me how the word got into the case, Dean's prosecutors revealed to the White House that he had just revealed the break-in from the Oval Office. Now, that wasn't supposed to go to the White House, actually. It was supposed to be a Chinese wall there and so forth, but they did have it. And Nixon's response to that at the time was, keep that secret. Do not reveal that to the court, although it was clearly obliged to reveal it, at least to the judge, if not to the court. He said, no, that's national security. Don't send it down. He gave that order to the Justice Department. Something like 13 days went by. And finally, Kleindienst, the acting attorney general, and Henry Peterson, the head of the criminal division, went to Nixon and said, we've got to send this down or we'll be prosecuted for obstruction of justice. So Nixon did say, okay, send it to him, but make it clear that it's national security. It doesn't have to get out. And that evening, he was on a call to Kleindienst about the situation. And Nixon said, actually, well, now they'll say impeachment. This is the first time that impeachment occurs on the White House tapes ever as a possibility. He says, this is say impeachment. And then they'll get Agnew. How will they like that? Well, Agnew was, of course, had to make a plea bargain for extortion later in the year. So he lost his impeachment insurance. Just as I would say, Pence right now has a degree of impeachment insurance for Trump, but he lost that. So Kleindienst said, make it clear that the judge doesn't have to put this out. General Haig, Chief of Staff, was sent to Washington, to Los Angeles with this news, I believe, to make this clear to the judge. Anyway, the judge knew he couldn't keep it secret because Dean was talking. So eventually it would come out and he would be found to have sat on it. So he couldn't do that. However, now in direct answer to your question, the way it came out in court was he called us, me, the defendants and Tony Russo, and the lawyers and the prosecutors up to the bench out of hearing of the jury, supposedly. And he said very quietly, he had just gotten this word about a direct burglary of the White House, from the White House of my former psychoanalyst. And he looked at me for the first time in the trial. His eyes had never met mine. I'm sitting there invisibly at the defense table. He looks at my defense lawyers never addressed me. For the first time, he looks at me and he says, Mr. Ellsberg, I don't have to put this out. I can keep it under seal if you want, meaning you don't want word, if you don't want word that you had a psychoanalyst. Well, now, having a psychoanalyst in Los Angeles is like a seal of approval. I mean, how do you explain not having a psychoanalyst? But in any case, under the circumstances, I said, are you kidding? I said, put that out. So he read it out, and that's how that happened. But he did not end the trial. The trial went on for about 2 more weeks. They brought Hunt back in front of the grand jury now, and he purged his perjury at this point and told about what he'd done. Liddy didn't. Various other people, Ehrlichman came forward and so forth. So every day there was a new revelation. And judges all across the country, we put in a motion to end the trial. Nope, refused. Then the people all over the country we heard were asking, why is this trial going on? What's going on in Los Angeles? As it's going on right now, as of now in London. And we eventually got the answer, in effect, because a leak occurred almost surely from Mark Felt, who wanted to be head of the FBI director. Deep throat, it later came out. But a leak came out in Washington paper that that Judge Byrne had been offered the directorship of the FBI. And now it so happens that Jerry Brown, as I think was Secretary of State of California at that point, had come to a fundraiser of mine and had told me, he said, I know your judge very well. Anything you want to know about him? And we asked, he said, his childhood ambition has been to replace J. Edgar Hoover, who had just died, hadn't yet died when he told me this, to replace J. Edgar Hoover as director of the FBI. That's his childhood, lifetime ambition. So now we're hearing that with Hoover dead, the judge had been offered this. The judge then said in court, I'll abbreviate this somewhat, but he did because we warned him that this had come out and we were going to raise it up, actually. So he came out and he said, I came out, but I didn't discuss the trial. There was no discussion of the trial. And of course, I told him I couldn't discuss it while it was on. Then it came out, by the way, that he had had a second meeting with Ehrlichman about this a couple of days later, on April 7th. I know that date because it's my birthday. We learned later. And again, he said he had not discussed the trial, but Ehrlichman remembered it differently. Oh, yes, he told me his plans he wanted for the FBI to do it and how anxious he was to get the job and so forth. Now, Byrne always said that he had not discussed the trial, although here he was having a discussion of this during the trial. So he said this, but it so happens that Haldeman took home movies of the president's meetings with everybody within his 8mm camera. And so later these were shown on NBC, and I watched my judge, Byrne, coming across the lawn at San Clemente, and Nixon coming toward him with his hand out. And this was the first meeting, Ehrlichman was standing by, and Nixon's first words I hear on the television are, well, Judge, it's taking you as long to end that Ellsberg trial as it took me to end the Vietnam War. Meaning, he wanted that trial over before the information, which Byrne hadn't yet gotten, got to court. So, of course, this does come out, as so happens. We again move to end the trial on this. He dismisses it. That discussion had no effect on him. And it goes on and on. Eventually, it comes out that despite a year and a half of FBI denials that they had overheard me, as Julian has been overheard every minute of the day in the court, they denied they'd ever overheard me. And suddenly the new acting director of the FBI, Ruckelshaus, learns from an FBI director, yes, we did have a number of overhearings of him. That comes out in court. So the judge asks for the documents on it. Let me see, what was overheard, so forth. They can't find the documents. They've disappeared from Hoover. They're not in the files. Well, since they were illegal, as in the case of Assange, they weren't in the FBI regular files at all. They were in Hoover's personal files. And the number 2 man in the FBI at that time, Sullivan, had warned the Nixon that these might come out in the Ellsberg case. And he was told, get them out of Hoover's files because Hoover can blackmail us with these illegal orders from the White House. And so Sullivan stole the files from Hoover's personal files and delivered them to Ehrlichman in the White House, where they turned up the day after my trial ended. All this is very complicated, but to show this rat's nest of mutual blackmail that was going on, they're trying to blackmail me illegally. That's a crime for them. So people who know about that can blackmail them with that. Hoover wanted to stay in office indefinitely, which he managed to do till his death by blackmail like this on various presidents. And in the end, however, it did come out. And the judge said, the totality of the circumstances in this case, after all of this, there's no one thing being allowed to have stopped it, amazingly, as in this case. Who knows what else may have to come out in this case to get a comparable result. But the judge did say, okay, then charges are dismissed. This case cannot be held, fairly. It offends the sense of justice. And he ended it. And it so happens that the headline in the LA Times, when we came to court that day, was John Mitchell, my first attorney general, who had led to this indictment, indicted. And later, of course, Kleindienst had to make plea charges and so forth and all the others. And I remember being asked on the courthouse steps when we came out from that, what are you going to do now after 2 years under indictment? I said, well, after 4.5 months in court, I don't think I'll go cold turkey. I think I'll spend some time going to other people's trials. And that was
that's a great story. We're joined now from London by Fidel Narváez. Fidel, can you unmute yourself, please? Fidel was the consul general at the embassy in London of Ecuador during this whole period. Fidel, before you joined us, we were talking to to John Kiriakou about the strong parallels between what happened to Dan that she's talking about, the government misconduct against him, which set him free from that trial, and the government misconduct we heard about in testimony this week against Assange. And even worse, Daniel said, because the discussion to poison or kidnap him went even further than what happened to Assange. So tell us, you were there. You must have had suspicions of all this surveillance going on, but were you even shocked when you learned the extent of it at any point?
Sure. Thank you, Joe, and a pleasure to share the panel with so distinguished friends. Yes, I was very surprised to learn about all this, not from the trial this week, because I know about the case quite well, because I am myself a witness in the case that's taking place in Madrid, in Spain. Julian is suing UC Global for spying on him. And I'm a witness in this. I am witness in that case. So I have seen myself quite a lot of evidence of the spying, videos, audios, images, and I was shocked when this was revealed a year ago. Basically, shocked in the sense that it shows that the spying was being made for the Americans, for the American intelligence agencies. But we were always suspicious of UC Global. I might say Julian, for certain, and me as well, from the very beginning in 2012, when Ecuador contracted this security company to protect the embassy and the political asylum living in the embassy. The embassy of Ecuador did not have any security company before that. We didn't even have security cameras inside the embassy. We didn't have any security guard, nothing, before Julian requested for asylum. So when Julian arrived, the first 2 months, while Ecuador was studying his case, Ecuador didn't grant the asylum the first day. We took 2 months to study the case very rigorously. We approach all the parties involved. We approach the British, we approach the Swedish, we even approach Australia and United States before we decide to granted the asylum to Julian Assange. So 2 months after Julian arrived, the first 2 months we were, myself, just Julian and me inside the embassy. We could not leave Julian on his own at all. So I stayed for 2 months with Julian Assange in the embassy. And when the asylum was granted, 2 months after he arrived, is when UC Global came into this matter. UC Global already had contracts with the Ecuadorian government. In Ecuador, they were looking after the family of the president. Let's not forget that the family of the president lives in Europe. The problem was that to bring an Ecuadorian company or to bring the Ecuadorian police or Ecuadorian military to look after the embassy, I think it was quite complicated because they needed visa in order to work in the UK. They will need a diplomatic visa. It was complicated. UC Global being a Spanish company, being a European company, it was easier for the government to charge them of the security of the embassy. Julian did not trust them from the very beginning. I did not trust them from the very beginning. They seemed very unprofessional to me. We were very concerned about the invasion of privacy, of course. It's not much we could do from the London embassy. The company had the trust from the high authorities in Quito. And one of the things that I want to highlight here is not only the spying, which is the main crime that UC Global did in my embassy, but it's also the misleading of my own government, the misinformation, the defamation coming out from the daily reports that UC Global was producing for the government. Why? Obviously, because they needed to keep their job. They needed to exaggerate any details that was happening in the embassy with Julian there, in order to in order to gain your trust. It's in the same way as if you take your car to a dodgy mechanic, they will find things that they don't exist there because they want you to feel that you need him and he's the only one who can repair that. It is obvious that this is a corrupt company. It's a mercenary company. So I'm not surprised that it was easily bought by the Americans. We were quite sure that they were spying on us. We used to live with it. Julian, we used even the diplomats there. We used the white noise machine for our own meetings. Julian used always the white noise machine for his meetings. Later on, he decided to have his more confidential meetings in the spots of the embassy where the cameras did not reach. Later on, he decided to do it in the toilets. And all the rest is now public. At some point, Mr. Morales, the owner of UC Global, come back from a trip in USA and told his employees basically that they are starting to work for the dark side. Basically, he sold the company to the people who he was supposedly protecting us. And that's the element that we didn't know.
So Fidel, the UC Global was brought in originally to protect Julian Assange, not to spy on him?
Of course, to protect the embassy, as, listen, the embassy was surveilled from day one by the British security services and by the British police. There was a displacement of British police outside the embassy for years, and when they replaced the police being physically outside the embassy, they replaced for undercover surveillance. And the British openly said, we are replacing this kind of surveillance for undercover surveillance. So we knew that we had in the neighboring buildings cameras pointing at our embassy. We have seen cars with long-range microphones outside the embassy. We knew that was happening. We didn't know that they were the Americans with laser microphones listening to what was happening in the embassy, as we have learned now. But we knew that the embassy was already surveilled. So we obviously needed protection. We needed a security company to protect us and to protect Julian, of course. But it's quite difficult for me to explain how my own authorities cope with a company that obviously was invading our privacy as well. From the Ecuadorian diplomats as well, we were complaining. I myself made a lot of complaints, verbal complaints, but I was seen already as very much close to Julian. So the company managed to mislead the authorities for many years. Maybe Daniel will remember once when he came to see Julian, I think it was in 2013, he was not allowed in the embassy. He arrived, I remember, with John Cusack and with Arundhati Roy. Yeah, so such distinguished visitors, they were not allowed in the embassy. Why? Because UC Global and the then ambassador were having some kind of problem with Julian's visitors and some forms that they needed to be filled, and the ambassador wasn't present, and the visit was not authorized, and it took us to reach Quito authorities, yeah, to explain we have very important visitors here. The security company doesn't allow them in. The ambassador is not anywhere to be reached. Please, we need to solve that. So all those kind of little problems that were with the security company and Julian, never with the Ecuadorian diplomats, the company managed to mislead, because in any prison, the Ecuadorian embassy was not a prison, but in any prison, the one writing the reports is the jailer. It's not the prisoner. So who are you going to believe? So they managed to, and this is a problem as well, because the daily reports from UC Global were used by the press, the Ecuadorian press, which is awful, yeah, to attack on Julian as a bad behaved guest, but some British media as well, yeah, in order to defame Julian. And I know myself, because many of these daily reports were leaked, that either they were false or they were totally twisted, misrepresented, exaggerated, etc., etc.
Fidel, I have a few more questions for you, but I want to throw it open now to discussion. Anybody jump in? Who's ever first to ask something or to make a comment?
Fidel, I just wanted to ask, over your years at the embassy, what, in addition to the issues with UC Global, can you tell us some of the most striking events that you were personally witness to? relating to
There were
Assange?
many. There were 7 years there. But let me tell you just one little example of why we stopped trusting UC Global at all. That happened in 2012, at the very beginning, when during the night, Julian, at 2 o'clock in the morning, somehow, heard that some things were being thrown at his window from the street. The only possible people throwing, we thought they were little stones to his window, were the British police. So he immediately went for the security guard that was inside the embassy to request him, please help me find out who is doing this from the street. Let's look at the security cameras. The security guard did not speak English. Julian did not speak Spanish. And basically the security guard got angry to Julian, saying, why are you doing 2 o'clock in the morning trying to look at the cameras? Yeah. Next day, Julian asked for permission to look himself to the security camera system records, yeah, to find out. He got granted permission by us, by the diplomats, and later a security guard came. He was not aware that Julian had permission and had a go at Julian. Why are you doing checking yourself the security cameras? The same security guard that did not speak English, Julian did not speak Spanish, there was an incident. Julian asked me to come and try to solve this in the middle of the night. I arrived, Mr. Morales was there, Mr. David Morales was there, yeah, because there was an incident in the embassy. I myself said, this is the second incident with the same security guard. I don't want to see him anymore in this embassy. And I want to listen to Julian, what happened. Julian told me all this story about middle of the night. To close the story short, I myself, with Julian, Mr. Morales, and somebody else from UC Global, look at the security camera records, videos, and saw how the British police from the street at 2 o'clock in the morning, 2:30, 3 policemen, 2 men and a policewoman took from the policewoman took from her pocket coins and started to throw the coins into Julian Assange window. This is not a game taking place in any London neighborhood between kids. This is the police throwing objects to an embassy. It's a serious matter. And the records were there. So, because the ambassador was absent, I instructed UC Global to take a copy of that video, which was evidence of the British harassing the embassy. Those videos were those copies were never produced. They were never produced. They claim that because the system was quite new, they didn't know that only records 2 days history, and then immediately it erases itself. It was incredible. They blame Julian for the whole incident. They wrote reports that were false. I myself was in conflict with the ambassador. The ambassador believed UC Global and not me and not Julian. So this is just one example of how life was very difficult for Julian Assange for 7 years with such a company that now we know basically started working for his persecutors.
That's incredible. Are there any other incidents like that that you would like to retell?
No, because we don't have that much time.
Yeah, just totally understandable. Alex, did you want to ask Fidel a question?
Just very quickly, did you ever feel frightened by these people? I mean, because they sound pretty, gruesome characters. I mean, were they threatening in any particular way?
There were many different security guards during those years. Some of them were better than others. Some of them were good guys, actually, and you can see how some of them basically became whistleblowers and said, this is not right, this is not fair. But some of them were quite nasty. We managed to get rid of them because they were repetitively unprofessional. And they were exploited themselves. They were not being paid enough by this company. Some of them have, and I know, they have demanded the company for abusing their working rights. UC Globally, in the last year, even falsified some documents with the ambassador's signature in order to deal with court cases in Spain, because their own employees were suing the company. And that's why basically Ecuador in 2018 got rid of UC Global, replaced it for a different company. But at the time, the government has already changed. So basically, in my opinion, the Americans didn't need any more a corrupt company in order to spy on Julian, because with the new government, basically they had the government to spy for them. And one of the things that I take from these court hearings is that the judge basically has on the table lots of cards to get out of what she had, the pressure she has. Yeah, lots of cards. The political card. This is a political crime. The awful conditions in prison. Yeah, the health condition of Julian. No, and now she has this one which invalidates any court proceeding. They were spying on Julian's lawyers. But not only that UC Global was spying on Julian's lawyers, and we assume that they were giving everything to the United States. When Julian was evicted, the new government, the government of Benny Moreno, seized all Julian belongings illegally. And between that, it's absolutely sure that he had confidential information about his legal strategy, about his documents, with legal documents that he was having with his lawyers. And we know that Ecuador has handed that over everything to the United States. That's no doubt, that's public.
Fidel, it came up in the testimony that a door was left open to facilitate a possible kidnapping. What could you tell us about that incident?
No. I think on the testimony, they say that there were discussions about that. There were discussions about that possibility. But I can tell you that I think it was the day before Daniel came in 2013 and he was denied entrance. There was an incident with the security guard, with the nastiest one of them, when the security guard threatened Julian with inviting the British police to come from him. And in fact, there are videos of the security guard leaving the door open, inviting the British policeman to come in and get Julian, and you can see the British police, one of them, right there, and he couldn't go in by the invitation of the security guard. He will go in by the invitation of the ambassador or the senior diplomat. That's why they didn't come in, but they threatened Julian with doing that. After that huge incident, that security guard was replaced, but what came from the testimonies is that they were discussing the possibility of leaving the door open inadvertently and basically allowing the kidnapping of Julian, and also the poisoning, which is shocking.
Wasn't there an incident where Julian heard someone trying to come in the window late at night? He testified about that.
There were a couple of minor incidents where people were trying to get into the embassy and ask for asylum, or they were trying to reach Julian, and the security guards acted professionally and basically stop those incidents.
Can you tell us, Fidel, whether they actually set up this live streaming back to the United States that was discussed? Did that actually happen? You know?
As far as I know, they didn't manage to do it. I don't think it's proof that they managed to do it, but they were trying to do it.
Can I, Joe?
Yeah.
Can I come? It's fascinating. That was wonderful testimony. We didn't hear testimony like that in court. But let me tell you the other side of an incident that you mentioned twice here now. When John Cusack, Arundhati Roy, and I came to the embassy, which you recall, we were coming during the hours that he was entitled to have visitors, and made arrangements in advance and so forth. And we're told, as you said, we couldn't come in. The new ambassador who had come there, the new envoy, had mad at Julian, didn't like Julian, unlike the previous one, and was closing down, making him incommunicado, in effect. So we were turned away. And as you recall, there's a British policeman right on the landing, right outside the door of the embassy. And we didn't know there were people right across the street looking at him all the time with their laser beam and so forth. But the police were very much in evidence. So we were turned away. Well, we were only there for a couple of days. Actually, the reason we were there was that Ed Snowden had gotten, this was 2014, not 2013, had gotten the Right Livelihood Award, the alternative Nobel Prize in Sweden. And Ed had asked me to be a guest at that. And John and Arundhati came also. So he'd been in Sweden, and then we went to Moscow to see Ed, Ed Snowden. Then we came back through London to visit Julian. So we refused to get in. Well, I was furious at this, basically, and I had an idea. And at about 4 a.m, I woke up and I was staying, actually, as I recall, at the apartment of McFudgeon, who is a big supporter of Julian, and the people who were supporting him on the outside. And I called his office and him early in the morning, knowing, by the way, that this must be one of the most tapped lines in London at that point. And I said, but that wasn't my reason mainly for calling. I said, I'm not going to go along with this. I'm going to go announce that we're coming again today. Again, it was visiting hours. They said there would be no more that week. And I said, no, I'm coming. And if they don't let us in, I'm sitting down in front of that door, which you remember very well. I'd lie down if necessary. And no one is going in or out of that embassy without having to step over me until they arrest me. They're going to have to arrest me to do that. And so I said, get a cameraman there, and we'll watch this, me get arrested on this. So we arrive, and the door is opened, and come in. Now we make fiesta and so forth. I probably met you, I don't know, in the course of that. Everybody very friendly. The door opened wide for us. One other little thing that I've never mentioned I've never mentioned that publicly before, actually. And another thing that I never mentioned, because it came at the end of the trial and there was so much else going on, it was this. When as I say, we'd been living essentially for more than a year on and off my wife and I, in an apartment building near the courthouse in downtown Los Angeles. And so after the final part of the hearing, 4.5 months in court every day, the trial ended miraculously, as this should end for the same reason. We moved out, and we learned within a few days that a CBS television crew had come in to shoot a commercial in our empty apartment, which we'd just left, because it had a very nice view out over Los Angeles and the courthouse and everything else. So a good place for a commercial. And there was some problem trying to plug in the cameras in the living room. So we were told by the guy who did this, the cameraman had previously been in the Army in counterintelligence service. So he unscrewed the plug in the wall and found a bug, which he very clearly recognized as a bug. He'd installed them, he'd serviced them. Maybe John Kiriakou has done the same. So he looked in the rest of the apartment and found more bugs in the bedroom during the entire length of our trial. So we didn't make a fuss over that because the trial was over at this point. But, and it would have been hard to prove exactly who did it. That wasn't too hard to figure out. So I really thank you for taking care of Julian, watching over Julian, for speaking out so frankly now. He had a good friend. And as you point out, the people who have just testified.
My pleasure and my duty.
What's that?
My pleasure and my duty.
Thank you. Well, the people who just testified at length are whistleblowers of the highest order at this point. And they should be testifying in America if this proceeds at all, which it should not, and absolutely. The judge gave them anonymity because the Spanish court had granted them anonymity. Their names are known to the prosecution and to the US and to the judge, but granted them anonymity because the Spanish court had agreed they were in danger of their life from your boss, David Morales. I don't know if you agree with that judgment or not, but if he did anything, of course, it would not be without the approval of his contract bosses.
No, Dan, James Lewis, the lawyer for the US government in court, has said all of this testimony that we've been discussing from these two whistleblowing former employees and partner is irrelevant. Now, Barreza said at the beginning of this hearing that she would have let everything in and later she would decide what's admissible and what's not. Now, she allowed this testimony. It wasn't challenged by the US except to say that it's irrelevant. So I want to ask Alexander a question because he knows the British system. And I saw some really interesting differences between the American courtroom and a British courtroom. One being, for example, Dan mentioned how they were brought to the bench with the lawyers. There's usually a private conversation. Here, when the lawyers and the judge was discussing in Old Bailey, it was out in the open. We heard all the discussions. I found that interesting. But more importantly, in this British court, we heard, and you wrote an excellent piece for us at Consortium News, huge details about war crimes, assassination programs, torture, and other U.S. misdeeds. And Dan, I want to bring you in too after Alexander speaks. I don't think that's going to be heard in Alexandria, Virginia, if Julian should go there. I don't think they're going to be able to talk about any WikiLeaks document because they're still considered classified, even though everyone's read them and it's on Cryptome and it's on WikiLeaks. All these documents are still classified. So I wouldn't be surprised if the prosecution in the U.S., Kromberg, will say we can't talk about it because that's classified. And so we did hear extraordinary detail in a British court that we probably wouldn't hear in an American court. Isn't that right, Alexander?
Well, yes, it is. And I think it is perhaps the most positive sign about how this particular judge may be thinking, that she's allowed this evidence. Now, can I just talk about this issue about, this information being irrelevant, about, UC Global? It is not irrelevant. I mean, you do not extradite people to a country whose government employs private contractors to spy on that person, spy on them when they're talking to their lawyers, and perhaps even plot to kill them. I used to work for 12 years in the Royal Courts of Justice. I know of cases where judges used to make orders to take people off planes that were going to send them to particular countries, where far less happened than that. I mean, this is highly relevant. This is absolutely fundamental. And if the judge who is considering this case properly considers this evidence, most of which is backed now by judicial findings in the Spanish court, I mean, she cannot extradite him. I mean, that's my own personal view. I mean, I can't see how she can extradite him. But you're perfectly correct. I mean, the one thing we've heard in this court is that we were able to hear this massive evidence about the work that Julian Assange and WikiLeaks did. And this massive evidence shows the extent to which they exposed war crimes, crimes against humanity, egregious human rights abuses, all of these things which the United States is trying to conceal under the classification process. He is being tried because he exposed those things, or rather, the United States is seeking to extradite him to the United States, to try him and jail him because he exposed those things. That too is a fundamental reason why he should not be extradited. And I'm going to just finish and add that while I was there at the very last day of the trial, yesterday, the actual hearing, and one of the things that is absolutely astonishing, which came out very clearly, is that there is still uncertainty about what precise charges Julian Assange is going to face if he goes to the United States. And the judge is actually asking the US government's British lawyers to actually clarify that by Monday. How can you actually conduct a whole hearing, discuss extraditing someone to a country where the charges may change from one day to the next and are still not even clear at this stage? There are, as Fidel absolutely rightly said, multiple reasons why he cannot be extradited. But this affair with UC Global ought to put the matter beyond doubt. And if Britain, and I speak now as a British citizen, extradites Julian Assange in these circumstances, then they will be directly complicit in the perpetration of the war crimes which he exposed. They will be complicit because they have been complicit in the punishment of the person who exposed them.
Alexander, if he goes to Alexandria, it'll be like in Dan's case, probably a strict liability case. He won't be able to say why he did what he did. We won't be able to discuss the classified information that was discussed in Baraitsa's court. So I think that's a strong, terrible difference there, that there was no public interest defense, where in the US, where we saw it on display in Baraitsa's court, because they were able to discuss why Julian did this. They brought witnesses in explaining the value of what WikiLeaks did. Dan, don't you expect, and also Alexander, that in the US it'll be a strict liability and we won't hear any of this if he gets that far?
Well, you can hear some of the substance of it as they explain, as the government takes a case of why this was so classified. And so they won't want to talk about parts of this that make the government look bad. They want to just, as in my case, pick out parts that don't look that interesting, but happen to be stamped secret. By the way, in my case, every page was stamped top secret, sensitive. In this case, nothing higher than secret, which, and even unclassified. But even so, they'll want to say, yes, this was stamped. They won't want to talk about the substance. But the point you just made, Joe, and I want to put it to Alexander too, to see if I'm right on this. My understanding that is, even though after the jury in the Clive Ponting case of a leak did acquit Ponting, despite an almost direct order, directive from the judge that he should be found guilty, They accepted the public interest case, that what Clive Ponting had put on was clearly in the public interest to know, whereupon Britain removed from the Official Secrets Act, as I understand it, an explicit public interest defense. So Ponting couldn't have put on that question, and what Joe is saying, why he did what he did, and whether it helped the public interest at all. But as I understand it, the European Convention on Human Rights is there as an appeal point, and which Britain is obligated to observe, and that does require, as it should, a public interest defense to be made. U.S. is not under the European Convention of Human Rights. They are not subject to it. They do not accept under the Espionage Act, which is a strict liability act. It just says you can only say, did you do the acts, that are forbidden here, not why you did them or what the impact of them was. He would not be able to discuss any of that. Therefore, Alexander, I'd like to put it to you, it seems to me that I don't see how the judge can remove him from the jurisdiction of Europe or London, where he would be subject in any case to the public interest defense under the European Convention. How can they extradite him to a country where he would not have that defense? That doesn't seem to me right.
Well, I think you're absolutely right. I mean, the fact is he doesn't have many of the protections which he should do. I mean, the public interest defense derives, as you correctly say, from the European Convention of Human Rights, which is a part of our law. It's actually part of our law. British courts must take it into account in any proceedings. They must take it into account in these proceedings. If he's going to be deprived of that protection and be transferred to the United States and tried in a situation where he would have fewer rights than he would in Britain, then I don't think he can be extradited. But I mean, it's only one reason amongst many why he can't be extradited. I mean, the UC Global one, I think, ought to, in any sensible place, put the question beyond any doubt. Of course, the Ponting decision and the change of the law that followed it was made by Margaret Thatcher's government, which is before the European Convention of Human Rights became part of our law. So the Blair government then brought it in 1998. It became part of our law in 2001. It became an effective part of our law. It still is an operative part of our law. And can I say, judges in Britain, certainly the senior judiciary, take it very seriously and are protective of it. And I think they will be concerned if they think that someone who carried out the trade of journalism in Britain, or at least engaged in journalistic activities in Britain, who is protected by British law through the European Convention of Human Rights, were taken away to a country where those protections were taken from him.
Alexander, the 1989 is the last version of the Official Secrets Act. Is that correct? That's
yes,
the one
it
you
yes.
referred to.
Yes.
Made
Yes.
that.
Yes.
Now, the Barrecha has asked several times of Lewis to get her the language of the 1989 Act. And I presume that's to see if there's dual criminality between the Espionage Act and the Official Secrets Act. We know the Espionage Act says that anyone cannot possess unauthorized possession of classified defense information, and that's why Lewis told the court that we cannot preclude prosecuting journalists. He's a journalist now, they admitted, but he broke the law. Is that now in the 89 version of the Official Secrets Act, that same or very similar language that no one, because I think the earlier versions of the Official Secrets Act dealt only with government employees. Has it? I think in 89 it was extended, am I correct? To anyone?
Yes, you are. And it's still extended, but the Article 10 of the European Convention of Human Rights, which is part of our law, says that restrictions of that nature can only be permitted where it is compatible with a democratic society. That is the fundamental protection, and that trumps the any restrictions imposed through the Official Secrets Act. So this is where the law is extremely complicated. The British authorities have not sorted out their laws clearly, and though they wanted to remove those protections, the fact that that Human Rights Act is there still provides them.
That sounds like there's similar conflict with the First Amendment and the Espionage Act.
Absolutely, it does. Absolutely does. Except, of course, that just as, well, actually not to say, in the same way as the First Amendment, the European Convention of Human Rights takes precedence. This is the law. This is the actual law of England. The Human Rights Act of 1998 says very clearly where there is a conflict between the domestic law and the human rights law. The human rights law takes precedence and is the one that should be followed.
But Joe, could I correct an impression?
Yes, Fidel, and then Elizabeth, and I'm getting out of here. You guys.
Okay. I think my understanding, and I want to put this to Alexander as well, is that under the British Official Secrets Act, journalists have always been understood to be subject to that. And that is the big difference between the UK on this point and the US. The First Amendment, which the British don't have, except to the extent it's reflected in the European Convention, the First Amendment earlier, before my case, was held to preclude using any law really, against even an official who was giving truth to the American public. My case was the experiment to abridge that right. But even so, for almost 50 years now, it has not been used against a journalist the way the UK Act has permitted. Now, we're going to erase that. What they're saying now is what the American authorities are saying now is no, it's in a British Act as well. But Alexander, I'd like to put to you, it seems to me that if Judge Beretzer does not recognize a difference here between the US and the UK, and acknowledges that it is right to send Julian Assange, a journalist, over to face US law, why does that not apply to Alan Rusbridger of The Guardian, or to The Observer, or to any English paper that printed the Chelsea Manning revelations at that time of torture? If Julian can be sent, why can't any British journalist who printed the same material that he did also be sent? That's the question.
It's an excellent question, and it's potentially, it answers itself, given that it is now accepted by the British Crown Prosecution Service that when Julian Assange was publishing these things, he was acting like a journalist. It can be done to any other journalist, and it makes the silence of most of the British media, as this extraordinary and very dangerous step is taken, it makes their silence remarkable. We've had some mumbled words from The Guardian, they oppose Julian Assange's extradition, but they don't. But at the same time, they are still criticising him. But the media as a whole remains extraordinarily hostile to him, even as, dare I say it, the noose is being tightened around their own throats. It's quite amazing to me. I don't understand it. I don't understand why they don't see it. It seems extraordinary to me that they should be, if you like, the handmaidens of power in this kind of case, when, as I said, it's progressing in a way that is dangerous to themselves.
Yeah, for half a century since my trial, I've been trying to tell audiences of media and even judges about this case and said, this puts a target on your backs, essentially, because the wording of the Espionage Act not only does apply to me, the strict wording, which I would say, not I, but other legal scholars have said, makes it unconstitutional in the US, but the same wording applies to all journalists, just as it. And I'm not sure, actually, whether the UK Act is as broad as this. Is the following, but the American Espionage Act implies that any reader of this material, anyone who receives it, as a matter of fact, Julian is specifically charged with receiving and holding in an authorized manner that's classified. Well, that's true of every reader of the Guardian or the New York Times or anybody else. They are receiving it. They're not giving it back to an authorized holder and whatnot. that wording applies to them. And for half a century, the Americans journalists have taken the attitude, well, the wording is there, but they're careful enough not to apply it to us or to readers. Well, that's changed. And so now it is being applied. And even so, they're not covering this trial. The Guardian is, actually.
Guardian is. I mean, what I would simply say is this. I mean, you know, for most of my life, I've been hearing this comparison between the journalism in the US and journalism in Britain, and that what can happen, the journalists in the US have far more protections because of the First Amendment than they do in Britain. In Britain, the culture has never been as open, or wasn't as open, as it is in the US. Now it turns out that that's not the case at all, and that the Espionage Act is being used in ways that, you know, once would have been considered probably inconceivable, but it is being used in that way. If that happens in the US, then the chilling effects in Britain just don't bear speaking of, because what the US does in Britain, we invariably follow. I mean, this is something that is absolutely obvious to me. I mean, to the extent that we've had a freeing up of the media in Britain over the last 150 years, it's partly because of the example of the US. If the US moves in the other direction and we collude in it here in Britain, then that level of freedom of the press that we still have is going to diminish further.
I have a quick question. Oh, Fidel, you go ahead.
Yes. It's a question. It's a question for Alexander, if he could refer to the case of Abu Hamza, when he was extradited by the UK. He appealed to the European Court of Human Rights. And the European Court of Human Rights allowed the extradition to take place because the United States supposedly gave guarantees that the man won't be subject to special administrative measures, given his health condition. The guy is double amputated, doesn't have any hands, doesn't have one eye. The result we heard in court by the lawyer of Abu Hamza is that the United States did not fulfill those guarantees.
No.
Basically, they have him in special administrative measures for years now, from 2012, 8 years. So I think that sets a precedent.
Oh, it does.
It sets a precedent because the United States, again, will want to give guarantees that they are going to put Julian in humane conditions and he will not be at risk of suicidal, of all of that. But there is a precedent that those guarantees basically were not fulfilled. They failed.
Correct. Yeah. Absolutely true. I mean, and it is a precedent. And of course, I mean, it's arguable that you should never have accepted those kind of guarantees anyway. And it is also, I would say, the case that if those guarantees are violated, then under the protections of the convention, the British government ought to be lobbying the US government to bring him back. Of course, they're not doing that. It has happened in other cases. It's not doing that. Now, in this particular case, I think partly because of the Hamza case, but because of others, there hasn't really been this pursuit of guarantees. The US government hasn't been making those kind of guarantees in the case of Assange. And I don't think that that's a direct issue here, but it does show that you cannot trust what the US says about the way in which someone is going to be treated if he is taken to the United States. Certainly you should not trust the United States when, as I said, its own agents have been carrying out the kind of illegal surveillance of him that you've just described in the embassy. spying on him even when he's meeting with his lawyers, and apparently discussing, in all seriousness, plots to kill him. I mean, that's absolutely should not be accepting any kind of guarantees in that situation.
I had one question following up on the subject of the press, and that is that given the testimony we heard from Cassandra Fairbanks, we can say that this is specifically an attack on the free press by the Trump administration itself. And we know that news media like New York Times, the Washington Post, and cable outlets like MSNBC, at least nominally, present themselves as very critical of the Trump administration. So doesn't this case represent the absolute perfect opportunity to substantially hit back against Trump, especially in election year? And how remarkable is it that we're still hearing crickets about it despite that? And does that this is directed at all of you, does this represent a loyalty to the intelligence community from the media that transcends, whatever the Trump administration basically is doing and the way in which it's hurting the free press, obviously?
Well, if I can just quickly say, I mean, this is perhaps more a question for Americans because these are American media, but I would say absolutely. I'm going to say one thing, which is that I've been slightly worried about the emphasis on Trump, because it seems to me that it isn't just Trump who has been after Assange. I don't want to, I don't want to understate the importance of Donald Trump himself and his role here, but it is this imperial autocratic presidency that has been emerging with all this enormous spread of its apparatus that we've been talking about, the way in which we have intelligence agencies that operate in ways that seem quite remarkable now. And clearly they have all become intertwined with each other. And to a certain extent, they become intertwined with the media. So yes, there does seem to be a kind of higher media loyalty to this overarching apparatus than it is to their own self-interest and the principles of the Constitution and the law, and dare I say it, of a democratic society, just to use the words of the European Convention of Human Rights. All of those principles, which ultimately make possible, as a free press, their existence. But that seems to me very clear. But others, no doubt, the other speakers obviously have perhaps things they want to say. Americans, and Daniel Ellsberg especially.
Well, thank you. I think Alexandra used the key word there, imperial empire. I think the deference of the press and the fact that they are more controlled, actually, in terms of these D notices, which tell them what they can and cannot say, which don't exist in the U.S. Except the U.S., of course, does give a lot of this stuff in advance to the White House to make sure they're not putting out anything and they get requests, which in the difference from England is they don't have to live up to the request. But in the case of, for example, the sort of thing that Ed Snowden eventually revealed, the surveillance, the Times was kept for a year from revealing that information when they had it by the White House telling them, blood will be on your hands, meaning that we will accuse you of having caused the next terrorist attack. And that kept the New York Times from repeating that, from revealing what they had before an election. It gave George W. Bush an extra 4 years. They're doing that. And they didn't reveal that until their reporter, James Risen, was about to put it out in a book, and they didn't want to be scooped by their own reporter. So they did eventually put it out, for which Bill Keller got a Pulitzer Prize, which he had earned. And what he didn't get was the journalistic equivalent of impeachment, which he had also earned for sitting on that for a year. But I'm very struck by your saying that as we get even worse in the US in this direction, in applying this directly to journalists, Britain will follow that, even though they've had the legal basis for doing that in the past. But now they will exercise it more if this comes on. On the press, as I said, they pretty well conceal the Catherine Gunn issue very much. Take the Assange revelations from Chelsea Manning directly. And a very important point you make, that it's definitely not only Trump. In the first place, the First Amendment did keep, before Barack Obama, there being more than 3 prosecutions, of which mine was the first, for whistleblowing. Obama brought 9. Trump has brought even more, and it's been predicted from the beginning of his term that he would probably be the first to apply it to journalists as well. But this war on journalism, in effect, on whistleblowing began in particular under Barack Obama, having been initiated under Richard Nixon. And I believe that the reason they were so vindictive against Chelsea Manning and Assange for putting out their information was in part because it revealed crimes by the government that extended into the Barack Obama administration, when she revealed an enormous pattern of torture, meaning turning Iraqi prisoners from Americans over to Iraqi troops, knowing that they would be tortured. That was, there couldn't be a clearer crime in the country, because the conventions and the laws that call for that make a failure to investigate a credible case, allegation of torture, or prosecute it as much of a crime as the torture itself. So this was a crime. It was an illegal order by the officers who said, don't pursue this. And what Chelsea experienced herself, and what she found 100 examples of, and by putting out all this, so much information, was a pattern, a policy of saying, don't investigate torture by Iraqis, which made us totally complicit in that torture. Now that process extended into the Obama administration. So it directly went to the White House. In other words, Barack Obama, yes, could have been brought in front of the International Court, Criminal Court, on this crime. And remember, I repeat again, torture is not only an international crime, and it is a domestic crime. It is illegal under the Constitution. It couldn't be more criminal. One person has gone to prison in connection with the torture program in this. And I think he's left our panel now, but that was John Kiriakou, who was speaking to us earlier. He went to prison because he revealed inadvertently the name of someone who was still a covert agent who had been a torturer. So for revealing the name of a torturer, and I would say, by the way, that concealing that is an abuse of the secrecy system right there, and is illegal. It's protecting a criminal, which is not supposed to be classified. For revealing that, John Kiriakou goes to prison for 30 months, and he's the only one who does. So what we're talking here is, on the one hand, government, talking with the US in the first instance, that is out of control of the law, of international treaties, of the Constitution, of domestic laws, acting lawlessly, a rogue, and not in one rogue instance, not a bad apple. As you put it, Alexander, I would paraphrase it, Trump is not the one bad apple in this pile. I would actually, it would be hard to find an American president since the beginning of the World War, I said, who could not be accused properly and convicted of war crimes before a tribunal that was actually objective on this, and crimes against the peace. But how did they get away with this? Well, by strength, but it's an imperial policy. And I think this deference of these laws in Britain that go even beyond as laws, what we have yet in the US, reflect nostalgia for the empire. The fact we were once the great mighty empire, of the world, and this is the way you have to run an empire. Well, what Trump is doing, what Barack Obama, every president you can name before him was doing, was managing an empire, which calls for, as Richard Cheney, the vice president, put it after 9/11, going on the dark side. An exact quote, Francisco, of Fidel, of Morales, right? We've joined the dark side. We've joined Cheney. Well, Cheney was somebody that I described in the following terms. I'll end with this. I took an oath as a Marine, but also as a State Department employee, as a Defense Department employee, official, like every official in the government and every member of Congress. And it was not an oath to Il Duce der Führer, the leader, the commander-in-chief, at all. It was an oath only to support and defend the Constitution of the United States against all enemies, foreign and domestic. Trump is not the first domestic enemy of the Constitution we've had in the White House. It was clear to me that Vice President Cheney, and this is not true of all the presidents have, in my opinion, covertly violated the Constitution when they needed to. I don't see them as having tried to overthrow and change our form of government. I believe Richard Cheney was a man who did mean to change it to an autocratic government of executive power only, and I think Trump is another. And that means that I see Trump as a domestic enemy of the Constitution, in the sense of the oath that I took and everybody in the government has taken to defend and support the Constitution against. And the ones who are telling the truth about it, one of them, John Kiriakou, who went to prison, I who faced it, and so forth, were fulfilling that oath. Chelsea Manning fulfilled her oath better than any other member of the government of the United States at that time. And the people who are continuing to lie for the president are violating that oath. So, Alexander, as you say, I think we're seeing now in London, and Joe, the English status as being under the rule of law, as obeying Convention of Human Rights, is being tested right now. And the U.S. as well, the U.S. would fail that test right now. We may be able to get back to it. Judge Beretzer has the opportunity actually to affirm England's rule of law at this point.
That's an absolutely brilliant point right there. She does. There's a lot weighing on her, isn't there? We talked about Cheney. That actually came out in testimony. His unitary executive theory that this is what William Barr ascribes to. In fact, the defense, and Alexander was in the court when this happened yesterday, the defense tried to put in a statement from Barr of September 15, in which he stated clearly that the discretion for who to prosecute or not lies with the executive, a king-like power, demolishing the so-called Chinese wall between the Department of Justice and the White House. So this has come out to Beretzer to hear on the empire. Daniel, not only is the government managing an empire, but they're managing a media that covers up for empire, which has never fully aired out what U.S. foreign policy has been like, what its real geostrategic and economic interests are, but they promulgate this myth of America spreading democracy. And who comes along almost single-handedly to lift that cover, to show what the U.S. Empire and foreign policy is really like? Julian Assange, and that's why he's in that glass cage in the back of the court. I want to end now, but I wanted to ask one question of Alexander about D-notices. My understanding is that the media does not have to follow the D-notice. They're not legally, is that right?
That is entirely right. I mean, they have no legal reality. In fact, in practice, the media always does. And that tells you an awful lot about the way things happen in Britain. I mean, we have this very strange system in Britain where the law, the law is outwardly there, but all kinds of conventions and agreements and gentlemanly pacts and people meeting in clubs decide things. So D-notices are a very real thing. They most definitely exist. If you talk to people like, Craig Murray, or he could tell you much about them, but they have no actual legal force.
You're not invited to those clubs, are you, Alexander?
I am not invited. I used to be. I used to be a member of the Military and Naval Club so many decades ago. I don't even want to remember. But I'm not a member now. Decided long ago that I didn't fit in there.
You're not in the club. So Daniel, I want to, and all of us who are on this panel, I want to end by going back to the beginning when we talked about the government misconduct that led to Daniel Ellsberg's case being dismissed, and now we have the strong evidence of government misconduct against Julian Assange. And Dan, you mentioned about normalization of activities that back in your day would not have been normal, would have been seen as the crimes that they are. You said when you were on the witness stand, the virtual witness stand, that what was put into the Chelsea Manning reports that she had a low-level access to about these field reports about assassination programs and torture would in your day have been put only in the top secret. And we also have the example that I like to give of the My Lai massacre and the collateral murder video. In My Lai, we had a whistleblower who was listened to by Congress, and then a journalist who reported it, who got a Pulitzer Prize and a full-time job at the New York Times, and at least one member of the military, though there should have been more, was actually in prison for that. When you look at collateral murder, the whistleblower who released that, unlike in My Lai, went to jail. The journalist who didn't get a Pulitzer and a New York Times job is now on trial and is in Belmarsh prison. And this is a huge difference between the two, and it shows, I think, how far the United States has gone. So I want to play a short video, and then I'd like Daniel and anybody else's reaction. In February, when we were in London for the first week of the hearing, I was able to interview there in Parliament Square after the rally, Yanni Varoufakis, the former Greek finance minister. And I actually said Daniel Ellsberg's case was dismissed because of misconduct. And I think even back then we knew something about UC Global. And I put it to Varoufakis, what has changed? Can you roll that tape, please, Kathy?
Dan Ellsberg's case was thrown out because of misconduct by the prosecution. As you know, they tried to bribe the judge, yes. The FBI directorship, and they bugged his psychiatrist. We have here in Assange's case, with UBC Global sharing with the CIA, the prosecuting government is eavesdropping on the defense preparations of the man they're prosecuting. In any normal case, that would be thrown out immediately upon a motion by the defense. What will happen? Why not this time?
The difference is that Dan was tried in a normal court.
Yes.
Julian will never be guilty.
He had a court with a jury, actually.
Yeah, Julian is going to disappear into a system where not even his lawyers would know the charges are.
Yes.
So,
yeah, I've been in that
habeas
courtroom.
corpus does not exist for you.
So that shows you 30 years, now 40 years later, how far
things are getting worse.
Gotten worse, yes.
Far worse. So we better do something.
Yes. Thank you very much.
Thank you.
Appreciate your time.
So that's the end of the film. Basically, I asked him, well, what's happened? Why is there a difference between Ellsberg's day and Assange's? And he said things are getting worse. Now we have Baraitsa is faced with this, as Alexander's pointed out. There should be an open and shut decision that has to be thrown out. So Dan, let me ask you, what confidence do you have that what happened to you will happen to Julian Assange?
Oh, confidence, I couldn't say. It's possible. It should happen. I didn't see that clip just now, but and send it to us. But it is possible. It's a challenge to us to follow up. And remember, it's not only the possibility here of ending a trial, which it certainly should do, and ending an extradition even certainly, which certainly should happen. But it's a challenge to that the possibility of this bearing on Trump's being in office, because if the mainstream media would carry this material, it would be one more element of extreme relevance to the electorate here in the next month. The criminality of Trump very much. It won't be the first, of course, but as I say, it's one more element, and the possibility of challenging, of overriding vetoes, of preventing him or others from vetoing an end to wars. All these are opened up as possibilities by this. And Joe, one thing, when you keep saying it's due to Assange, I know you'll mean to add, and of course to Chelsea Manning, who was the source for this information and who took this on herself to reveal it, and not only what the U.S. was doing, but directly, but what other countries, what did she put it, the first world was doing to the third world. That's the basic notion of empire here in general, and the colluding empires. So there is a real possibility, I think, of change. It should happen. Does that mean it absolutely will? No, certainly not. Like any of this, we keep talking about wake-up calls. Well, what are we talking about? The ordinary sleeper? There's been one waking call after another, month after month, year after year, and nothing seems to happen. And yet some things come along that do make a difference. The Rodney King video of Rodney King being beaten, and now the George Floyd video, of course, made an enormous difference in people's willingness to act when they actually see it. It did wake a lot of people up. And what preceded that, Chelsea Manning's release to Julian Assange, to the mainstream, the video of US troops in a helicopter committing murder from the air, which is, let me just tell you, to a first approximation, is the American way of war. Killing, and a lot of that involves murder of civilians from the air, war crimes. And that's what we saw. Now, it did get attention. Did it end, these practices? No. As one person who was on the scene, who rescued children from this murderous helicopter, and being ordered not to do it, not to continue to do it, said, this is an everyday practice. This man who was on the ground, who went to the two children who were being fired at, their father was killed next to them. When he rescued one, went back for the other, his lieutenant told him, get back to your job, don't do that. And when he reported it to higher officers, they said, man up, get the sand out of your vagina. Don't worry about this. Okay, well, that didn't have the effect of the George Floyd killing, the George Floyd video, because after all, it was foreigners that this was being done to. And Americans are like everybody else. They don't react as much to what our country does to other people, to foreigners, as they do to our own. And the George Floyd arises. But when you say, has it gotten worse? Actually, it was Barack Obama, of course, who brought the Chelsea Manning case, not Trump. And someone asked him, this is on video, you can see it on YouTube, Barack Obama and Ellsberg, Manning, then Bradley, someone asked him at a fundraising dinner, Mr. President, isn't what Chelsea Manning, then Bradley Manning, charged with doing the same as what Ellsberg did? And Barack Obama said, the material that Ellsberg dealt with was classified at a different manner, a different level from Chelsea's, from Bradley's. Well, that was true. Hers was secret or lower. Mine was entirely top secret. He didn't mention that. But yes, the situation is getting worse. It's in the process of getting worse. And if the media continue to ignore this evidence of criminality and the threat directly to them, then they will be left with no First Amendment protections against investigative journalism in the so-called national security system, keeping in mind that essentially none of this has to do with national security. It's classified for the job security of the people indulging in this criminal talk and criminal planning to a large extent. So, but in that field, they want to make it so that the public hears only from the press handouts, what the government wants them to hear. And truthfully, most of the press in the US and Britain would be content with that.
Daniel, what will it mean if Baraitser ignores this government misconduct as your judge was unable to? What will it mean for our societies?
It would mean
Baraitser ignores this government misconduct, unlike your judge, which couldn't have.
Well, the notion of a rule of law here will be even more blatantly mocked in this point. Law is what, as Nixon put it, what I say it is, what I do, that's what's legal. And what you do that I don't like is not legal. And that is not a democracy. That is not a republic. It is an autocracy. It's essentially fascism. Not all autocracies are fascist. Let's agree to that, no doubt. But this one is looking like it can be going that way. The word fascist in America, ever since the Second World War, has been thought of as an epithet, as rhetoric. That's in the past. That's Germany, Japan, Italy. We're done with that. We destroyed that. That's so when the word comes up, people say, well, that's overkill, that's rhetoric, that's hyperbole. In fact, it rules you out of the conversation. And I've observed that that taboo myself about using it. I don't call people fascist, you know. I'm looking at Donald Trump now in a different light, and this month is in particular even more. There are people who have said in the past, Donald Trump, in 2016 in the press, Donald Trump is not a fascist. Let's be technical here. He's a right-wing populist, as we're seeing in Europe so much right now. That's what he is. Why? Because here are the criteria of fascism. He doesn't call for violence. You know, he doesn't have a party, an SA of brown shirts, black shirts, who use violence against his dissenters. He doesn't try to overthrow the nature of the government, the constitutional government, various other things. So he's not a fascist. Well, I think we're looking right now at a would-be fascist, as a wannabe fascist, Donald Trump. And here's a little exercise people can do. Look up on the web for photographs of Benito Mussolini. And I won't really try to imitate it, but take a look at it. That outthrust jaw, the scowl that we saw the other night on the drawing, I believe he's consciously imitating Benito Mussolini physically, but there's no, take a look at it. But in fact, there's, in terms of what he's trying to do, he is trying, Benito Mussolini, of course, invented the word fascism for his party, the National Fascist Party. Well, here's the thing. Hitler was never very widely popular in this country, ever. Neither was Tojo of Japan. Mussolini was. In circumstances of a pandemonium like this, a pandemic that has closed down the economy and has made us forest fires that are going around, protests, all that in the 30s, the Depression then. Mussolini was widely admired in this country and by major politicians, by press, by the New York Times, and everything else. That can happen again. I think a third of this country or so are quite ready for an authoritarian leader like Il Duce. And Trump has to be that, because otherwise, under a rule of law, if he loses office, he is prosecuted. He has committed so many criminal violations so clearly, the indictments are so clear, his choice is between staying in the office and risking prison. And I say risking, but under a rule of law, actually going to prison. And he's desperate. He will do anything when it comes to starting a war, invoking martial law. We see him denigrating the basic aspect of our democracy, the election process, very much. And the other aspect of the First Amendment, he is absolutely trying to hack away at that. So this election, I think we're seeing a chance to avert fascist dictatorship, just as Judge Baritzer is facing a chance to rule in favor of a rule of law. And it's a challenge, in other words, of people to act like Chelsea Manning or Ed Snowden or Julian Assange. It's possible they will live up to that.
Thank you, Daniel. If anyone else has something they'd like to add, otherwise we're going to end this segment. We have another interviews coming up with two Australian journalists. Fidel.
Well, basically just to congratulate all of you, not being for the alternative media that were following this case, like yourselves, like Kevin Gostola, like Craig Murray writing daily reports, we wouldn't know much of what was happening in the court. I had the privilege to be in court most of the days, and I feel quite optimistic, actually. I didn't start optimistic at the beginning, but after those 4 weeks, I feel a bit optimistic. I think the chances are 50-50 at least. The overwhelming evidence that we saw there in favor of Julian, yeah, is so much that I cannot see how the judge is gonna ignore it. It's been proven beyond a doubt that Julian Assange did not hack anything, did not conspire to hack anything. It's proven beyond a doubt that he responsibly redacted all his publications. Yeah. So I can see bit by bit more voices coming forward in his defense. For example, my wife is British, and she was telling me today, I didn't listen to that yet, but there's a journalist here in UK called John Simpson. Is kind of icon of the BBC. Yeah? He has just come forward with a good report in support of Julian, apparently. And one of the things I have noticed in these 4 weeks, although there was not good, proper coverage about the proceedings, at least I have not spotted negative reports or basically openly attacks saying he should be extradited. He should be extradited. I have not read that. People are completely silenced. So I feel a bit more optimistic about this. If we know that this is not the end on the 4th of January, is not the end because either party is going to appeal. My great concern is about Julian's health, about his personal situation in this. It's more than 10 years that the man is being demolished by the establishment. The Julian I've seen in court these last 4 weeks is not the same Julian that came in 2012 for asylum. They are destroying him. So whatever the result is on the 4th of January, during the appeal, he should be provided bail in order to face the next stage in freedom. That's the least that should happen. And I am very confident that if we don't win this one with Barrister, we will definitely win in the next one in the Supreme Court. So thank you all of you.
Thank you, Fidel. Alexander, if you want to have the last word.
Very briefly, just on what Daniel Ellsberg was saying. I mean, I come from Britain, obviously, as the great imperial power. You do not want to go where Britain went. I mean, power is very corrupting. Being an imperial power is extremely corrupting. The democratic movement that began in Britain to take hold in the late 19th century understood that, and for that reason, it was opposed to imperialism. Not consistently, not always. There was lots of backtracking, but it is not surprising, for example, that British workers supported the North during the American Civil War and opposed slavery, and that British cotton workers received Mahatma Gandhi in Britain. I mean, you do not want an empire. It is incompatible with democracy. It leads to the gross legal violations that Daniel Ellsberg was talking about, and the extraordinary concentration of power in the executive that he was also talking about. The second thing is, I absolutely agree with Fidel about this legal process. I started it with profound pessimism. I think that over the course of the proceedings, the defense, which has been brilliantly conducted, by the way, I mean, they've done the lawyers that are representing Julian Assange have done a superb job in the most difficult circumstances and have put this extraordinary case together in a remarkably short time. I think they've made massive inroads. I think the tide of opinion in Britain is shifting, and I think even within the court, the tide is shifting. So I am also realistic, but also optimistic, or at least hopeful that the outcome in the end will be a good one.
Thank you, Alexander, and thank you, Daniel Ellsberg and Fidel in London, and of course, my co-host, Elizabeth Voss, and our producer, Kathy Logan. That's the end of this segment. We're now going to show a taped interview we had earlier today because of the time difference with two very prominent journalists, excuse me, in Australia, Mary Kostakidis and Andrew Fowler. So, we're now joined from Sydney, Australia by two prominent Australian journalists. Andrew Fowler, who wrote the book, The Most Dangerous Man in the World. He's just come up with an update of that. It's essentially a biography of Assange, certainly one that focuses on his work at WikiLeaks. And he may be the most informed journalist in the country, in Assange's native country, about WikiLeaks. And Mary Kostakidis, of course, well known to Australians as the presenter of SBS News. Thank you, Mary and Andrew, for joining CNLive. So we've heard in the live segment from Daniel Ellsberg, and he spoke about the parallels that he finds between the abuse of power that led to the dismissal of his case in 1971 for leaking the Pentagon Papers. Nixon was desperate to prosecute him, but when it was revealed that his plumbers had broken into Ellsberg's psychiatrist's office to try to get his medical files and get dirt on him, and also that they had wiretapped him and tried to bribe the judge in Ellsberg's case with the FBI directorship, it was a mistrial, and he walked free out of that Los Angeles courtroom. He thinks, Ellsberg does, that this is going to happen, could very well happen with Assange. I think things are different today. The country's come, the US has come a long way when you think about the reactions, for example, to the My Lai massacre evidence that came out and the collateral murder of WikiLeaks. The reaction to My Lai massacre was quite astonished. People were shocked by it. They actually had a whistleblower who was listened to at the Congress. They actually had a journalist who wrote it, Seymour Hersh, who as a freelancer got a job at the New York Times and a Pulitzer Prize. So, and they actually arrested and prosecuted at least one soldier out of that. Whereas collateral murder, the whistleblower who brought the story wasn't listened to by Congress, was jailed. The journalist who broke the story, Assange, didn't get a Pulitzer Prize. He's in prison and now on trial, and no one was investigated in terms of the perpetrators, the pilots of that helicopter, for example. So that shows me, I think, how the U.S. has declined in 50 years. Another point Ellsberg made in his testimony, by the way, was that what Chelsea Manning had access to, these field reports, would never have been in the Vietnam War at that level of clearance. That only top secret would have had information about an assassination program or torture. So things have changed a lot. But so let me start with you, Mary. We'll talk first about Ellsberg and then other parts of this case. How do you see the information that came out from the two Spanish anonymous witnesses about the continuous surveillance, particularly of his lawyer, his privileged conversation, the discussion of an assassination plot and kidnapping? Clearly this is on a par with what happened to Ellsberg, and that led to his case being dropped. What is your view now of how this could play out?
Well, I think Ellsberg's highlighted a key area, where a key basis on which the case can be thrown out, of course. The problem is, this is testimony. We don't know how the judge is going to view it. What would be required would be a decision from the Spanish court. If the Spanish court found that this had indeed happened and they penalised the people, the people responsible, I think then there's a much greater chance of her taking it on board. to date, all her adjudications, bar one, have been in favour of the prosecution. It was the not issuing the medical statements where she agreed to support the defence's request on that, and that was also supported by the prosecution. So I think she's a real black letter judge. And I don't get the impression that she's looking for ways in which to deny the extradition. The feeling I get as an observer is that she will be looking for ways to rationalize or, explain her decision to proceed with it. And I'm very concerned about how the whole political issue has been dealt with, the political motivation. They've really focused on the definition of political as party political, not as political as in political science. So they've really narrowed that down.
Andrew, your view of what is the consequence of the testimony from the Spanish witnesses, you think?
I think the testimony from the Spanish witnesses is absolutely crucial, because they not only provide testimony, they also provide evidence. They have screenshots, they have hours of tapes, they have information about the spying on journalists, about the information about spying on lawyers. They were there. They actually put the bugs in the building. They changed the cameras. How do we know that they did that? Because you've only got to look at the cameras and you can see how they've changed. There are pictures of them actually installing new cameras, new microphones, and they swear on testimony that that's what they did, and that they did it secretly to hide information, to hide the fact that they were spying on Assange or from Assange. So their testimony is very, very powerful. I think that the idea that they need to actually prove it in the court in Spain, where Morales is charged with specifically spying on client-lawyer meetings. That's an offence. So he's specifically charged with that, something which, if the judge accepts, had happened, whether or not the court case has reached a conclusion, is enough for her, I would have thought, to say that this is a political offence, and this is an offence which prejudices Assange's case, and therefore the case should be thrown out. Because I think that if the prosecution had evidence of the strategy being used by Assange, then clearly they have the inside running, and it's illegal in Spain, it's illegal in Europe. I do believe it's illegal in the United States to actually spy on the advice that a lawyer gives his or her client. So I think that information and the testimony that apparently she will hear in, I understand, in secret, some of that testimony, would be extremely significant. And she also has to worry about not just the black letter law interpretation, but I think how the judges will be viewed in history, how her contemporaries will view her, how her superiors will view her, not just her political masters, Priti Patel in the Home Office in Downing Street, but how she'll be judged, how she will be judged, how the judge will be judged, and I think that will play on her mind as well. I do think that the issue of spying on Assange is something which still has a way to travel. I mean, who knew? Who got information? Who got that information? And what did they do with it? We know that, for example, that Assange, there's evidence, rather than saying it's certain, but there's evidence that Assange was spied on by UC Global, and it's not just an assertion by these two people that are giving evidence before the court. It's actually can be traced through a conversation between a journalist called Cassandra Fairbanks, who works out of Washington, that she had with one of the White House insiders, a guy called Arthur Schultz, who is an advisor to Donald Trump Jr. And without going into too much of the complication of what happened, Cassandra Fairbanks visited Assange and told him some things that she'd been told by Arthur Schultz. Now, later on, Arthur Schultz rang her and abused her and said, why did you tell him those things when I said you weren't to tell anybody? And the question is, how did Schultz know that Fairbanks had told Assange anything? And the reason I would suggest is because he was in the loop, the link, he picked it up from the White House or the State Department, that the information had traveled via UC Global through to either the White House or the State Department. Now, if that's the case, the next link is, what does the Department of Justice know about it? What did they know? How much information did they draw, and how did it shape their case? And it's closing that loop, which would allow for, I think, the case to be, from what I understand of the law, though I'm not a lawyer, I'm a journalist, to be thrown out. But that's a long way to go. I'm not too sure that the judge is going to travel that far, but certainly there's a lot of circumstantial evidence and hard evidence that shows that the information did enter the inner circles of Washington.
You sound, excuse me, quite optimistic there in a way. Well, there's some optimism in what you're saying.
Yeah, there is optimism because it's hard evidence, and Cassandra Fairbanks, she has recorded this stuff as well. It's not just her recollection or her notes. She actually has recorded this material, and you can hear it. I mean, it's on the internet. You can play the conversation between Cassandra Fairbanks and Arthur Schultz, and there it is. And he's saying what she says he said, and it's very conclusive that there was a flow of information from the embassy to the heart of the Washington establishment and to an advisor to Donald Trump's son, Donald Trump Jr. That's pretty close. And considering that the evidence that we've heard so far in the court has suggested that ever since Trump became president of the United States, they ratcheted up the attack on Assange inside the embassy. The spying started in earnest within weeks of Trump being elected. So you put that together with that information and you say, well, there's a conspiracy here. It's run by Trump, run by his administration to gather information on Assange and prosecute him. To prosecute him when the Obama administration had decided not to prosecute him. So 10 years after the event, suddenly with a new president, we've got new cameras, new microphones, new surveillance, and evidence of this information going to the White House 10 years after the offenses were committed, and 4 or 5 years since the Obama administration decided not to proceed.
Yeah, and Cassandra Fairbanks' testimony was key for the defense because she laid out from these conversations with Schwartz that Trump had personally ordered the arrest of Assange, basically. We also heard a lot of testimony about William Barr, the Attorney General, believing this unitary executive, that it's up to the president to decide who to prosecute or not, which is punching huge holes in the so-called Chinese wall between the White House and the Defense and the Justice Department, although Barreza did not allow on the final day of testimony Thursday this statement from Barr in which he laid that out. But Andrew, you said interestingly that you didn't think the case in Spain had to conclude, that the evidence presented, because of the photographs, etc., is strong enough. If Barreza admits this, by the way, because she said she's listening to everything and will decide at the end what's admissible or not, which is, it's possible she doesn't admit this because the defense's argument is that this was all irrelevant. And I think that's based on what Gordon Cromberg, U.S. Attorney, Assistant U.S. Attorney in Alexandria, Virginia, has written in his affidavit that none of the surveillance material that was gathered would be used in the prosecution. So they're not denying that they did the surveillance, are they?
Well, the question is, is it a political prosecution? Well, since I would have thought spying is a political offense, and hacking into, if you want to call it that, into a foreign computer is a political offense. And if Donald Trump was involved in any way, indirectly or directly, his administration in spying on Assange, who they may see as an enemy of the United States, this is a political offense. And this in itself, I would think, would be enough for the extradition process to be stopped, because it's my understanding that a political offense would render the extradition unviable. So it depends on what judgment call that she makes. I mean, this is a very complicated and long-running case with many different levels to it. But to simply look at it and say, this guy, Julian Assange, committed these crimes, he's not a journalist, it's a very low bar to get him to America to say he's got to answer these very serious allegations about breaches of the Espionage Act, is a pretty simple case to run, because you can argue, well, you know, there's a case for Assange to answer, send him to America to answer it. The problem is, it's not that simple. It's actually a political vendetta against him. And every single bit of information that I've looked at closely and examined has pointed towards it being that. It's a political persecution. And that's a judgment call that the judge has to make. And she has to make that based on circumstantial evidence, shreds of truth, shreds of information, and make it and come to a conclusion. Now, she may well not do that. She may well, as Mary said, go to the black letter of the law. But I'm not too sure that that would save her on appeal. And I think she has to be careful about that. I think that would be weighing pretty heavily in her mind as a black letter lawyer. She's now got to deal with something which is extremely complex and extremely political, but extremely clear to all the people who look at it for what it is, rather than delving into the subsection, whatever it is, of the Espionage Act or the extradition treaty. It's pretty much an open and shut case of persecution. It'll be more than interesting to see what kind of conclusion she comes down with. But I imagine it's weighing pretty heavily on her mind. She did say she was going to make the decision after, or the determination after the presidential election. And I couldn't hear what she said, but exactly, or what actually the audio was pretty terrible on this case, just by the way. It was pretty shocking to try and listen to it and cover it. And Mary did a very good job in unraveling it and making it clear, because I was having great trouble, as many other people were as well. But what that actually meant and what they talked about, Fitzgerald, who's the defense QC, and the judge, I couldn't quite ascertain. But the date of the election and the role of the election and Trump was playing on her mind at that time. And I'd suggest for very good reason, because she knows this is a political case and a political prosecution, and that's what she has to deal with.
Well, Mary, I was going to ask you about Andrew's point that this is a vendetta against Assange, unless you wanted to add something to what you just heard from him.
So, I mean, it's clear to us that it's a political case. It's clear to us that it's a vendetta. In the court of public opinion, if the public were able to sit in on those 4 weeks of hearings, you know, it's very clear. Here's this person who's just exposed war crimes and abominable behavior. And he's the one that they want to lock up in a shoebox for the rest of his life. But the public haven't seen that. The public haven't heard the evidence that had the Guardian journalists not published that password, none of this would have happened. None of it. Because no one would have downloaded and de-encrypted that file. So you wouldn't have names published. This is a major problem. The public didn't hear all this. This has all happened in a bubble somewhere in a you know, up in space, where a few of us, a handful of us that are engaged with this, you know, we've observed it. What I'm concerned about with the whole political issue, and Andrew went through it in very good detail there, is that there wasn't a focus on a definition of what it is to, you know, what is political, what does political mean? So espionage, national security. How can national security not be political? And if that's not tackled, she then has to go on what their arguments are. And their arguments are that this is a party political issue. For me, the problem there is that the prosecution have a point. Obama didn't prosecute, but he didn't shut down the grand jury. He didn't shut it down. And my concern is looking at, having observed the way her mind seems to be operating, I don't know that she will be convinced, I don't know that she would come down on the side of it being political. The other point is the American intel spying on him. I think, as Andrew says, yes, there's evidence there. I'm not that clear on how much of that is coming to her. I thought it was just the statements, but if there is also supporting evidence, that's fantastic. However, I think that would be even, that'd be strengthened if the Spanish court made a decision. And then finally, we have the health issue. And I hope that she doesn't just rely on the arguments, that she has a really good look at depression and autism, Asperger's herself, because you need to understand those two disorders, illnesses. Well, I think depression's an illness, Asperger's is more, personality type. She needs to understand how they operate. Julian can function very well in this situation when he's engaged in a process that is trying to save what he's fought for and to save his life. Once you take that agency away, once you completely, once a person has absolutely no control over their situation and their future, that's when depression hits. The reason he's able to focus is because he has hope. If you don't understand that and you just take on board what the prosecution is saying, that, oh, well, look at him, he can, function really well, that's not Asperger's. How can you possibly be mentally ill? That's a real problem. There, I have more faith, if you like, in what she might do, because the fact is, in order to become a judge, you have to be pretty damn smart. So I'm hoping she'll do the right thing.
Well, Mary, before I wanted to introduce the health issue, I wanted to ask you more about about the vendetta that Andrew spoke about. And there seems to be a case of selective prosecution. Assange, The Guardian, Der Spiegel, the New York Times, El País, they all published the same material at the same time, and that's what he's being charged with. But in particular, and Krypton published the decrypted, unredacted cables that had the informants' names in there, and they weren't charged. John Young, the founder and who runs Krypton today, said law enforcement never came to him. So certainly the New York Times has not been charged. So that, I think, points out how this is a vendetta against Assange. And two things had to happen that really changed the government's position. One, they went into this saying he's not a journalist. That's in Kronberg's affidavit. And then it clearly became that he is a journalist, but the Espionage Act allows us, nothing in the Espionage Act that precludes us from charging journalists. This was an extraordinary line that the prosecution had to take. And then they also made it clear that it was only because of the reach that WikiLeaks had that they didn't go after Krypton and these others. So I think that I just wanted to make that point about the vendetta. It's clear when you looked at, they didn't charge anybody else for the exact same supposed crime, but only WikiLeaks. I think part of it is because they can manage establishment media much easier than they could a guy like Julian Assange, who clearly was out to reveal crimes, alleged crimes that they've committed anyway. So let's, you introduced the topic of the health. That took up a big part of this hearing, and essentially the defense was trying to show that he is suffering, he has had a lifelong history of depression. We didn't report a lot of, I don't think you did either, Mary or Andrew, a lot of the details of his medical history, which were disturbing. I never heard a lot of that. I don't know about you, Andrew, having written a book, an updated book. I wonder if you heard some stuff that you'd never heard, but so he has this lifelong history, though, of depression we could discuss, and suicide was spoken of. That has to be reported. He's a high risk of suicide if he's sent to these horrible American prisons. So what did the defense try to do? Say he's really not off. The prisons really aren't all that bad in America, and he really isn't that sick, is he?
Yeah, they really made it out to be some sort of holiday resort. It was just shocking, actually, to listen to. But fortunately, the one of the witnesses towards the end, Lindsay Lewis, the lawyer, I think she rebutted almost every point that this staged step down in SAMS is just, it's great on paper. It doesn't actually happen. And they are, even if you do earn a privilege, one extra phone call a month, it's arbitrarily removed because you've done something wrong. You've asked someone, your son, who is an approved member of the family that you can talk to wish happy birthday to your grandson, with whom the grandson doesn't have approval to communicate with you. I mean, it's just nuts completely. Also, I think very, very importantly, she made the point that the undertakings that the US gave to the UK government in their application to extradite, they've reneged on. I think that's a very important point, and I think it's a point the judge has to take into account. Certainly the politicians should take it into account. It is a political case, and it certainly would be a lot simpler if a politician had the courage to say, look, we can't extradite this person for these reasons. In the February hearings, when the prosecutor, in his opening remarks, he was addressing the media and saying, this has got nothing to do with you. This is really all about publishing names and putting people's lives at risk. During that very first day, when the judge was trying to establish dual criminality, she asked the prosecutor, if you put aside the computer intrusion charge, is obtaining, receiving, publishing a crime in itself? Well, it took quite some time for him to answer that question. And in the end, he had to say yes. So it was very clear from day one that this is about prosecuting journalists. In the September hearings, we've heard the prosecutor say several times, the United States government has never said it won't prosecute journalists. Despite sending this message loud and clear, I haven't seen a single headline anywhere in the world that says the US government is, going to prosecute journalists. I mean, they still haven't got it. The MSM, they just haven't got it.
I mean, the charge says publishing. Two of the counts, 16, 17, talk about publishing. Well, who publishes? Publishers and journalists. So it's another way of they've shape-shifted. They're just moving around. They're just trying to find some ground where they can score their points. And I think, Mary, it's really significant, that issue of the medical condition, and the prosecution have taken every single trick they could pull to discredit the people who were talking about his medical condition and the conditions under which he may be held. I mean, some of those cross-examinations, I thought they actually went too far. I'm not saying, you shouldn't be robust and question people, but some of them were asking, I thought, what I call vaguely insulting questions of the people who were expert witnesses, to the extent that the judge was showing some discomfort herself at times about whether or not it was right to question someone's credibility, when clearly they were extraordinarily credible, particularly the prison warden who was giving evidence there, who spoke about what it's like to be in the Supermax under SAMS. And they were asking her questions like, well, okay, if it's good to talk to the prisoners like you think they should be talked to, and you say that no prisoner is allowed to talk to anybody, why didn't you talk to the prisoners and stuff like that? And it was completely, it was so far out there, it smacked of desperation in an attempt to rip someone's credibility down. And of course, she was extraordinarily credible. And that's probably where they fear there's a weakness of their case, is that they won't be able to get Assange to the United States because the fear of him suiciding or being put in such a terrible condition in the United States that it's not seen to be a humanly acceptable place. And don't forget, we're sending, we are, or the United States is trying to extradite somebody from the UK to enter their system of government, their system of justice. And quite frankly, looking at that sense of, looking at that system of justice from across the Atlantic in the United Kingdom, looking back and looking at the United States, they must be asking themselves serious questions about the way in which the judiciary, the Attorney General, and the President operates. I mean, if it wasn't the United States of America, you'd say it was basically either a developing country or a country with the skids under it. It was being run by a dictatorship, the way that mates are being just given a free pass. It's not a good look, and I think it runs in Assange's favour.
Well, yes, Mary?
I'm not as hopeful, because what we're seeing here is the rise of authoritarianism, and if we look at our own politicians, then I don't know that their ethics and principles. We have our own scandals here. The problem is most of us are I think disengaged from that. We're all struggling with how we're going to live, I suppose, our own lives. I don't know that we're well, the way Stuart Rees would put it, and he's been a human rights warrior, is that we need more civil disobedience. We need to not be so compliant. We need to be thinking about the things that we're losing as we allow governments to move further and further towards an authoritarian state. And I don't know that our public, not just in Australia but elsewhere as well, is that engaged with these issues.
I wasn't really talking about the Australian public. I was talking about how the British judiciary would view the carryings on in the United States. I mean, they must take that view and say, this doesn't look like a functioning democracy at the moment. It looks like a country on the road to authoritarianism, if not at the gates. And I think that would play in Assange's favour. Now, I wouldn't hang my hat on that one. And as I say, it's a low bar to get him across the Atlantic to the United States. He doesn't have to be proven guilty of charges. There only has to be, my understanding, a case to answer. And it's such a low bar, which is why the mental health issue and the political argument is so strong, because you've got to stop him being extradited, not argue that you'll win the case if he goes there. He must not go to the United States. That's the number one issue.
But yes, Mary?
No, I think the problem is that the UK and Australia are the US's closest allies. So I don't have as much faith in them being able to look at the US and say, oh no, well we don't really, that's not us. Because the problem is that is what we have become as well. And I'm not that confident that the UK is that much different.
There was interesting that Barreta seemed shocked that Mark Summers, one of the defense attorneys, seemed to be questioning whether there was interference from the executive branch into the judicial branch. She asked him, are you actually suggesting that? And he said, well, that's what's written in a lot of these decisions, that they defer to the executive judges. So that's the key point you've hit on, as well as you, Andrew, about the authoritarianism, and whether if she cannot many people in our system cannot accept that we've become this way. Got to believe and grasp on to the long-held idea that we're democratic and that we go around the world invading the country, the US, to spread this democracy. So in order to not send Assange there has to be something wrong with us. And will they be able to make that conclusion? Would she be able to conclude that? That's the question.
That was a great moment, actually. And Fitzgerald had to repeat it 2 or 3 times and explain to her, no, it's a word that the courts use. And then, of course, the lawyer Lindsay Lewis was able to give her an example. I'm wondering, though, whether that's in relation to the specific issue they were talking about, which was about appeals centered around conditions in prisons. I don't know that it was a general comment about decisions of the judiciary. And, you know, I guess you could argue that in assessing those situations, you do have to take into account what experts at the prison are putting to you. So I'm not sure, but you're absolutely right. She was gobsmacked, which was good to see.
And let's not forget, by the way, it's her decision is not the final decision.
Yeah.
Which means that whoever, I suppose, wins or whoever loses will appeal to the High Court, and they'll certainly hear the appeal. I mean, I'm not sure of the process, but and what those private investigations are going on. The question of those 2 Spanish witnesses, what weight they have, whether they re-give their evidence, whether they can be re-interrogated, whether a decision by the Spanish court would have any effect or not. If a decision were made between whatever decision, let's say for the sake of the argument that Barresta comes down with, to extradite, and then there's an appeal, whether or not the Spanish court decision, if it were to fall later, would have an impact on the High Court's decision. One of the, I suppose, elements that, which in looking at the way that the court has tried to control information, is quite interesting, and it's very dark and it's not very positive for Assange. But to witness this event on camera, you have to be a member of an international federation of journalists, and then you have to put your papers through and become accepted, and then you can watch the whole proceeding. Members of the public are not allowed, are not given access to this information. They're not allowed to see the court. People like Amnesty International and other human rights organizations are not allowed access to the internet version. And you ask the question, well, so why is that? Why is it? You understand, maybe you could say journalists, yes, journalists governed by the rules of journalism and the laws laid down by the court, the way that journalists behave in court. That's fine. But the public are only being kept out of this, and the human rights people, not because there aren't enough seats in the court, but because they've decided, the court's decided that the general public and human rights organizations are not to get access to this material. And my question is why? It strikes me that it's to do with one thing, that's control. There is a certain control of the media. There's a certain control over the way that the media is deferential to the court. Members of the public and independent organizations, not so much. So there's a real fear in the court that if the truth of this got out, and if people could actually watch this trial, this hearing take place, they would be appalled at what they saw. And it would generate a backlash against the persecution of Assange, and it would actually lead to some civil action that they're worried about. I can think of no other reason why you wouldn't allow non-journalists to see what was going on in a court. Normally the only restrictions are the number of seats there are in the court. Since we have the internet, anybody, anywhere in the world can see this. My question is, why can't they?
I think one reason may be that there was an extraordinary airing of US misdeeds, to put it lightly, war crimes, and the conditions of their prisons. I don't know if it was extraordinary to hear that in a British court, a court of an allied nation, to hear that come out. And that really was at the heart of this. Assange revealed this, and they're punishing him for that. And I don't know how many people, as you say, they didn't want a lot of people to know that, did they? And the media, of course, only reported generally when Assange had an outburst from behind his glass cage.
Yeah.
Mm.
So it's a political, oh, sorry, Mary.
No, go ahead.
So it's a political trial, it's a political consideration. The restriction on information, the shutting out of the public and human rights observers, and the controlling of the media, the control. You're in here, you're a member of the Federation, you're bound by their rules, we can control them, it's part of the control structure. They can't stand the fact that actually, that this is actually something that, if it breaks out into the broader community, will have political consequences. And the political consequences may be much bigger than the case that they brought against Assange. So it's about control.
And human rights organisations would be amplifying precisely those messages. Can I just raise something that does concern me? I don't know how this was resolved at the end of the last day of the hearings. The whole issue of the new allegations, they weren't raised at all. We didn't see any evidence. We didn't hear any evidence, and we certainly didn't hear a defence. I understood that Gareth Peirce was putting in a submission to indicate how they would handle it. And I think what happened at the end of the day is that submission wasn't accepted. I don't understand the implications then for how the judge is going to take those new allegations into account and make a decision. Do you know, Joe? Did you?
It's a very good point you're raising here. She did deny that, and saying that they had their chance to ask for a delay in this hearing because of the late submission of a new extradition request based on the superseding indictment. The defense took a gamble and said no, they didn't want to prolong Assange's time in prison. That was the reason they gave, but they didn't have an opportunity to delay this, and they didn't. So she has not been forgiving at all towards them on this question at all. She did not want to say anything about the superseding indictment for some reason.
But it doesn't explain why the prosecution couldn't present their evidence regarding the new allegations. So we don't know. We
didn't want it challenged, obviously. They didn't want the defense to challenge these new non-charges, this new conduct, as they call it, which are really amount to certain new...
But given they issued a second superseding indictment, that's what the court is dealing with. And part of that, those new allegations didn't make their way to the surface. We just didn't hear. We didn't even hear what they were. They weren't articulated. So I don't quite understand.
Considering that as part of her decision, which is troubling.
Yes. Yeah.
So are you saying then that those allegations, which involved the two, if you like, felons, that were apparently being encouraged to do all sorts of things, the conspiracy, those statements were not lodged in the court, not publicly, as far as I know, were they?
No, there was
not publicly. No, we don't know. I mean, no.
And that's what we're saying. It should have been, obviously, if this is going to be taken into consideration as part of the decision.
So she made a ruling that the defense couldn't now have leave to make a submission on that. But what was her ruling on the prosecution's evidence? We don't know.
No. We don't know that, but that's certainly, yes, that's not open justice, I would imagine.
Yeah, and also, you know, I would have thought that having watched it over the weeks, what struck me, one of the things that really struck me quite hard was that towards the end, the judge was racing towards a deadline, was pushing all the time, pushing and pushing. And I'm sitting there watching this hearing take place, and I'm thinking, you know, this guy, Assange, this is his life. We're talking about 175 years in prison in a hole in the middle of the desert. I mean, it's the end of life. And we're talking about a schedule of getting things done and getting written statements pushed through fast and things like that. I was appalled by it. I was truly appalled by watching that court and the process that played out. I didn't think it didn't seem to look like a court that was investigating an allegation of a possible crime. It looked to me like it was a factory turning out a predetermined product to just churn it through and get done with it. That was quite shocking.
I agree with you, and that's why all the more so those when the camera cut to Julian, those moments were so poignant because this is about a human being, and there he is. And then we occasionally saw moments where he's talking to Stella, talking to his lawyers, and that the contrast between that, the sheer, you know, the humanity, and the judge who really, obviously, we all felt was just ticking a box towards an extradition. That's certainly.
I did think that too, Mary, and I must say I just saw Julian there several times in the glass cage, and I thought it was a gross obscenity to see somebody who'd done so much for journalism and done so much for human rights, exposed so many war crimes and evidence of war crimes, to see him in the dock. Whereas the people that have perpetuated these awful crimes against humanity are walking the streets free. And he's the copy. Yeah.
Sheer Kafka, that's what it was. 4 weeks of Kafka.
Yeah.
I think that might be a good place to end our conversation with Andrew Fowler and Mary Kostakidis from Sydney, Australia, about the just concluded 4 weeks of testimony in the extradition case of Julian Assange. Andrew and Mary, thanks very much for joining us today.
Get out your notebook.